I'm on YouTube.
Okay, good morning, everyone. Looks like we have a full house. I'm going to try and get through. I know from reviewing the calendar, there are a number of days that we're going to get through pretty quickly and probably just get announcements. And there's some that I'm going to need to spend some more time with. So I'm going to try and get announcements as quickly as possible and get everybody on their way as quickly as I can. And I'm sorry that there's weird sun thing happening, and I hope y'all can see me. But starting with position number 1, Fasil Menegstab versus Kinnaman. I'm sorry if I mispronounced anybody's name. I know Mr. Maddox had a conflict and had to be upstairs with Judge Ellerby. Mr. Maddox on?
Your Honor, can you hear me?
I can. Hi, Mr. Maddox. I see you now.
Well, I hope I don't look too funny with my eye patch going on, but Your Honor, we're not ready to try the case. This is the first setting, and I've had all this eye surgery business that came up, and then after the first round of it, that's when your calendar came out.
Yes, sir.
It's like, well, just another day in paradise for me. So I'm hoping that, and I hate to come to the court with my hat in my hand, but I can't remember the last time I came to court 39 years with one eye and half baked from anesthesia, but just don't.
That's an excellent description, Mr. Maddox. I appreciate that fully this morning. What says opposing counsel? Is Ms. Lawrence counsel in that case, or?
Yes, ma'am. I tried to get a hold of her this morning, and I hadn't heard back. But in fact, when we got the calendar, we tried to schedule something, but I was in kind of la la land with the first thing, so it just we got messed up. That's the short legal version of it.
Well, I'll tell you what, Mr. Maddox, if you can sit with me for a few minutes, let's wait until see if we hear from Ms. Lawrence, and Mr. Freehoff, if you'll email Ms. Lawrence and find out if she's held up or what's going to happen. And then we'll see what we can do about finding a little bit more time for you guys to get this case ready.
Will do.
Great. And the other case I've got, Your Honor, it's 11 o'clock, and that's with Judge Williams. So
okay, well, I'll get you on your way before that.
Yes, ma'am. I hope so.
Okay. Yes, Mr. Freehoff.
Oh, no, Judge, I was just saying I will get on trying to contact Ms. Lawrence and let you know what I find out.
Okay, thank you. Yancey versus Maddox.
Good morning, Your Honor. I'm Alonzo Nelson here for Ms. Maddox.
Good morning, Mr. Nelson.
I have a 9:30 in front of Judge Ellerby as well.
Yes, thank you. No, I think I got your two conflict letters confused, Mr. Nelson. I appreciate that you have a 9:30 in front of Judge Ellerby. And do I have someone here on behalf of the Yanceys? Mr. Hodges, perhaps?
Your Honor, if I may.
Yes.
I don't see him. He sent me his portion of the pretrial order on Monday.
Right.
I sent him back mine on Tuesday, and I haven't heard anything else from him.
Okay. Mr. Nelson, if you need to take a pause and jump on with Judge Ellerby, the beauty of Zoom is that you can. Can you hang out with me for a little bit longer if you need to multitask with Judge Ellerby and do that while we reach out to Mr. Hodges and find out what his status is?
I can, Your Honor.
Okay. Thank you, sir.
Thank you.
Ivy versus Judge Ward and the City of Atlanta.
Good morning, Judge Amanda Johns on behalf of Mr. Ivy.
Hi, Ms. Johns. Did you find a court reporter?
No, Your Honor.
Okay. One of the things I was intending to do was find out if I had any court reporters. I expected there were a couple of these matters that would have court reporters, particularly the Wycus matter and the Patel versus Bailey matter. Do either of you, counsel, have court reporters on standby for those hearings?
Judge Brian Knight for Bree Wycus. We do have a court reporter. I think their name's Samantha Brown from Hughesby that's supposed to be on. Is she on?
I don't see anybody, and I don't see anybody raising their hand claiming to be a court reporter. But Ms. Johns, my intention, if you'll be patient with me, was to either impose upon another court reporter that it might have already appeared, old school style, assuming that you could take care of the cost, or if I need to, I can get my court reporter to jump on briefly.
Judge, maybe there's a mistake. I do see Ms. Jones has the Wycus matter on hers.
I see. Ms. Jones.
Trying for today. Yes, I'm not. I didn't know if there was someone else, if there was a conflict, but yes, I'm here on the Wycus matter.
Okay.
Ah.
Ms. Jones, I don't mean to impose, but would it be possible, old school style, for me to, if Ms. Johns can take care of the cost, for you to do takedown on another matter that's on my calendar this morning?
Yes, that's fine.
Thank you, ma'am.
Judge, if I may, we actually have two cases.
Right, you have Ivy and Riddick, correct?
Yes, yes, Your Honor.
Okay,
That I'm trying to get takedown on both under directions from my office. I just wanted to be clear about that.
I'm also going to be reaching out to my court reporter and see if I can get her on for you. What is your time announcement on those, Ms. Johns?
Well, Your Honor, I'm a little curious if the court, they're both, I mean, there are different factual iterations in both of the cases, but they're the same legal terrain.
I know, but the city filed a responsive brief that wants to argue that Paris versus Atlanta is not dispositive of the outcome. And so
Yes, so if we, sometimes judges have asked to consolidate things and handle them I don't expect it to take much time. In fact, I'm in both of those cases, I intend to make a very brief argument and reserve most of my time for a rebuttal.
okay.
I would imagine maybe 10 minutes.
Okay, thank you, Johns. I appreciate it. And who do I have on behalf of the city? Ms. Brown or Mr. Carter?
Good morning, Judge, Miss Comer, Tyler.
Oh, hi, Ms. Comer.
Yes, how are you on behalf of the city?
Thank you. I appreciate that. And how long do you think your presentation would take in each of those cases, Ms. Comer?
Probably about 10 minutes. It shouldn't take long.
Okay, excellent. Thank you.
Thank you.
Okay, and then I have Bree Waikus, who are probably all mad at me because I made y'all do extra work here on the court's own sua sponte motion or order to show cause regarding attorney's fees. I've read your briefs. Mr. Knight, what is your announcement in terms of time for presentation?
Sure, Your Honor. I think I can do my portion in 15 minutes, Your Honor.
Okay, Ms. Mandel?
I think I'll be much shorter than that, 5-10 minutes.
Okay, I'm going to say 20 minutes and see if we can keep it to that. Okay. Patel versus Bailey.
Good morning, Your Honor. Jamin Chavda for Mr. Patel.
Hi, Mr. Chavda.
How
Good
are
morning,
you?
Your Honor. Ken Thompson on behalf of Mr. Bailey.
Hi, Mr. Thompson. And we are here today because there is a restated complaint where there is a third motion to dismiss. I believe the briefing, Mr. Thompson, indicated that I needed to have a hearing to allow you to present evidence regarding any decision on the merits of the motion to dismiss. Are we all in agreement procedurally? That's what we're here on today?
Yes, Your Honor.
Yes, Your Honor.
Okay, excellent. How long do you think that'll take, Mr. Thompson?
I anticipate it'll take 15 minutes, 15 to 20 minutes.
Okay. Thank you. And Mr. Chavda, anything different?
No, about 15 minutes. I usually end up going a little over, so it's a 15 to 20 as well.
Okay.
Thank you.
Thank you. Okay, and then I have a motion to disperse funds to Picky Pickens in the interpleader matter. Who do I have that's counsel for Picky Pickens, which is
Good
just
morning,
a
Your-
name to say?
Yeah.
Good morning, sir.
Good morning, Your Honor. This is Buddy Huntley, and I'm here on behalf of Picky Pickens.
Okay.
And I have Mr. DeSillis on the line as well, who's the
Okay.
owner of Picky Pickens.
Okay. And I will tell you, sir, that the main reason we set you for hearing was simply because the original application that was filed, one had some age on it, and two did not have substantive support for the basis for Picky Pickens' claim to the excess funds that were sitting in the court registry. But since we set it for hearing and asked you guys, my review of the record last night indicates that you have provided us with documentation regarding the basis for Picky Pickens' claim to the excess funds. And I'm not aware of anyone that's objected, and that motion is approximately a year old. And so I believe that I would be authorized, now that I've got that supporting documentation, to go ahead and enter that order authorizing the disbursement of the excess funds.
Yes, ma'am.
But what I would need you to do is submit to me, please, an email Word version form of a proposed order authorizing the distribution of those funds. And if you would please attach the deed that I saw that provides the basis for Picky Pickens' claim to the excess funds.
I will have that to your honor in the next hour before your calendar call is over.
Okay, excellent. Well, thank you, Mr. Huntley. I appreciate it. You and your client can be on their way.
All right. Thank you. Have a great day.
Thank you. You too. And then I have Wimberly versus Haybeth. Please tell me that y'all got this figured out. Was there a payment, Mr. Haybeth?
No, Your Honor.
No. Do I have Mr. Reynolds on the call?
I'm here, Your Honor. Good morning.
Hi, Mr. Reynolds. How are you?
I'm doing well, doing well. I'm talking to my client via text. He was trying to join the call here.
Okay.
And he sent me a number of documents, again, showing the attempts for it to go through. I do see something where ACH is scheduled, but it has not reached my account yet. So as I suspected, that short time frame proved a bit daunting for him to accomplish, but it's scheduled. It does show that he tried to make the wire. As we had ran into previously, the wire amount is over the limit that he can wire. So we have to do it by ACH, which takes longer. It's not an immediate thing. So that's where we're at.
Well, I appreciate, Mr. Reynolds, your efforts. I would be interested to know given that we, including myself, after the hearing already knew that they wouldn't be able, that your client wouldn't be able to schedule a wire that large from that account, right? Because of his prior experience with that account. I'd be interested to know when the ACH was initiated, but my order, I think, was clear that the payment had to actually have been made, not attempted, not initiated, not begun, but actually made, given the extended difficulties that there have been with trying to get payment to Mr. Haybeth. And so I think, absent anything, I mean, to me, the purpose of today's hearing was for y'all to come either tell me there's been payment, it's done, we've got it worked out, or there's not been payment. And if there's not been payment by yesterday at 5 p.m., which it sounds like everybody concedes there's not, although I understand, Mr. Reynolds, your client's position is he's attempted to initiate the payment, that Mr. Haybeth would be entitled to the writ of possession that he is seeking of the property that is currently being possessed by your client, Mr. Wimberly. Mr. Namatbaksh.
Judge Krause, good morning to you.
Good morning, sir.
We would ask for an immediate writ based on the non-payment issue. I'm happy to send to Mr. Freehoff a proposed order to that effect. And
that was going to be my request. Yes, sir.
Absolutely. And we would also ask for dismissal of this appeal. This is a hearing that is pending also in magistrate court. And once we have the reinstated writ, we would appreciate this case going back to where it was initiated in. And ultimately, I think Mr. Ray may have an interest in working out a short-term stay, and we can work that out outside of the Superior. We would ask for that dismissal in the interest of just judicial economy, so we don't have to come back out here for what seems to be already a figured out kind of dynamic.
Okay, Mr. Reynolds, what are your thoughts on the dismissal?
Obviously, my client has made good faith efforts to make that payment. And I don't know if you want to get into this now, but I can share our screen so you can see those attempts and the time period as the court wanted to see. I can show that to the court as well, if you'd like. But given the foregoing and his good faith efforts to make the payment, I do think it's proper for it to remain open so the underlying issues can be addressed. Well,
my question, so in revisiting the motion to dismiss, I think there might be, the writ of possession, I think it's a done deal. Mr. Haybeth would be entitled to possession of the property. But to the extent that there is any sort of dispute about the dollar amount that's owed, that would be the purpose of continuing an appeal. And that's what I question, is whether or not that's really an issue in this case. It sounds like everything I've heard from all the parties has always been about possession of the property. And in fact, the only thing I've heard from Mr. Haybeth is that the amount of the judgment is actually lower than the rent that Mr. Wimberly owes, according to Mr. Haybeth. And so my understanding of the purpose of the appeal going forward would be for a substantive evidentiary hearing, bench trial, on the amount of the judgment, the money judgment, not the possession of the premises. I think you might be right, Mr. Reynolds, that I should keep that one alive temporarily, but if substantively that's not what the parties are interested in litigating, then I'm not sure why I should keep it open. What are your thoughts, Mr. Reynolds?
I understand your point on that, Your Honor, and I think you're actually accurate about that, because I want to say that the judgment was around 37, if I'm not mistaken.
I don't know the amount, but I know the amount was 24 for back rent, and then 10 plus, I think 10.7 for monthly rent, which Mr. Habeff in our last hearing had argued was lower than was actually required in terms of additional payments based on the lease language.
So is it the court's position that even if we're able to show the dates that the attempts were made and confirm to the court that there was a good faith attempt to pay and that the funds actually are scheduled to hit our firm's account, can be put into the trust, can be put into the registry of the court today or tomorrow?
No. I apologize, Mr. Reynolds, but to be clear, I worded the order the way I worded the order for a reason, which was given the history that, and I don't blame you, but given the history that Mr. Wimberly has, it has been between the parties of Mr. Wimberly attempting payments that for some reason or another did not go through, my order required that payment actually be made by 5 p.m. yesterday, and it wasn't. And so the answer is there will be a writ of possession issued as soon as Mr. Habeff's counsel gets that to me. We will issue a writ of possession. Of course, the parties can continue to negotiate, because by the time you get that on file, you may have those funds in your trust account. And if that's the case, then y'all probably have more conversations to have. As to the dismissal of the judgment, I'm going to hold that open briefly. The appeal itself, simply because, as I said, the answer is to set an evidentiary. Yes, sir.
I was going to say, if that's the case, Your Honor, there's not an opportunity for us to continue with the writ, then we do not object to the appeal being dismissed.
Okay, then that's what I will do. Can you send me a dismissal, separate dismissal order to accompany the proposed writ of possession that you're going to submit, Mr. Nabat-Baksh?
Judge Krause, I'm happy to do so.
Okay, excellent. Thank you all. I appreciate it. Y'all may be excused unless you need anything else from me on that matter.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Have a good day.
Thank you.
Bye.
Okay. Do I have Mr. Maddox? Have we found Ms. Lawrence? I see Ms. Lawrence on the call now. Excellent. Hi, Ms. Lawrence. How are you?
I'm doing well. Good morning, Your Honor. I apologize. It appears we had some scheduling issues, so thank you so much for your patience.
No problem.
Let's get that addressed.
No problem. So before you joined us, Mr. Maddox was advising that y'all are not ready to try the case, and that he's had some issues going on that have made it difficult for him to prepare the case for trial, and that he would like to push it. I wanted to, get input from you, not only to confirm that you agree to that, which it sounds like you would, but also realistically what your thoughts are on when this matter might be reset.
Yes, Your Honor. I have spoken with Mr. Maddox. I was aware of that he had some things going on. So I have no objection to that request. I agree we're not ready. I know he and I had previously discussed mediation and getting that coordinated, which, unless he tells me otherwise, I think we were on board to do. So I think that might be a good avenue for potentially trying to get this resolved while we wait to appear in a new trial calendar.
Okay, well, that was actually my question though, is probably, I mean, I can put you on the October calendar, I can put you on the November calendar. My question to you, Ms. Lawrence and Mr. Maddox, is realistically, are you going to be ready in October, or do you want me to put it in November?
I'd suggest
I would request November.
I'm sorry, was that both of y'all said November?
Yes.
Okay, November it is. Just so you know, to the extent, I do want to let you know that there was a partial motion for summary judgment that was filed. it was filed after the deadline to file them pursuant to the scheduling order. And so obviously the substantive issues you might raise and we might discuss as part of the entry of the pretrial order and or discussing what will be presented to the jury, but the motion for summary judgment itself will not be considered. Okay.
Okay.
That's number one. And number two, the way my trial settings work is you'll get another notice that you'll be set for a pretrial conference in early November. And then you will be set for a trial date, I think is the last week of November. I've got to check on that though, because I'm pretty sure that last week of November is the Thanksgiving is the third week of November and the last week of November is an actual business week. So just giving you a heads up that that's likely when you would be placed on a calendar, but you'll receive a notice of it.
Very good, Your Honor.
Okay. Thank you both. You may be
Thanks so
excused.
much.
Thank you. And Mr. Hodges and Mr. Nelson.
Yes, ma'am. I'm unmuted. Russell Hodges.
Hi, sir. How are you?
I'm doing well, Your Honor. I think on our case, and that we put in pretrial orders that there's two of them. We haven't incorporated them yet, but we both have done our proposed pretrial. This case could be greatly simplified. I anticipate this case being greatly simplified. We had to file it by the pending administrator. I think that will be the administrator very shortly. I think, as a matter of fact, I have an 11 o'clock Zoom with the probate court. Where I've asked that the caveat to the administration be dismissed, since she said she does not want to be the administrator and doesn't object to my man being the administrator. So
and I will, forgive me for interrupting you, Mr. Hodges, but honestly, you're getting right to what my primary question was, is I've had a couple of these come up. I mean, I understand the relief that's sought in this case is associated with deed records over which I have exclusive authority as the Superior Court, but it sounds like the underlying substantive issues are set to be litigated in the probate court, or are they not?
In the probate court, we anticipate bringing the two properties that went out by deed supposedly prior to the death of the decedent back into the estate.
Right.
Through the probate court, and the appointment of my client as the administrator. So that will all be cleared up. I still have a tortious interference with expectancy in your court that I do intend to pursue. And the only thing is, will I need to have an expert testify as to a forgery, which I can do easily by November, possibly by October. Your Honor, all I can say is I think by 11 o'clock today, I'll have a lot of things cleared up. I'll be the administrator. And then I've talked to the district attorney because there was some hanky-panky about the witnesses and the notary on the wills. And they're actually entering into diversion agreements. Clerks in the Superior Court Clerk's Office, Fulton County, are entering into diversion agreements because they falsified the time and that they were present at the signing of the deeds. And I talked to Mr. Herzog yesterday, and he told me that this should be done shortly. And so when they do that, then he said the clerk of the Superior Court will attempt to put the deeds back where they should be. Now, does that mean she's going to unrecord them? I don't know. But that's what he told me yesterday afternoon. So I guess going back to it, I think things will be greatly simplified. I think some of the stuff will be handled in the probate court. I do have the tortious interference in your court. I do intend to pursue that.
Okay. And I understand that you intend to pursue it. I guess if the tortious interference claim factually is entirely based on the interference with the expectancy of recovering those two real property parcels that are to be litigated in the probate court, right, as to whether they're part of the estate or not, right? Because if they were validly transferred out of away from the decedent prior to her death, then they wouldn't be part of the estate.
That's correct.
If that matter is going to be litigated in probate court, would it make sense for this court to hold off and let the probate court do its work?
I think the probate court's going to do 3/4 of your work. There'll be damages. I'm seeking damage.
Right. But we wouldn't be relitigating the underlying substantive issues if both parties have, I mean, they would be collaterally estopped, I think.
Yeah, I think I'll have everything but damages.
Okay. Mr. Nelson, what are your thoughts on that, sir?
Your Honor, I disagree entirely. First of all, the probate court doesn't have authority to set aside a deed. So that is something this court has to address. We have not conceded that Mr. Yancey should be appointed as the administrator. Mr. Hodges filed a motion last week asking that the caveat be stricken. We haven't responded to it as of yet, but it's not right for that type of response yet. The underlying claims here, and I missed the early part of Mr. Hodges' announcement because I was in Judge Ellerby's court. But there's a question here of whether or not there's been a waiver of claims relating to one of the properties here. There was a dispossessory earlier. But again, I don't anticipate that this is going to be as neatly packaged as Mr. Hodges seems to indicate it will by the probate court, because the deed issue has to be addressed in this court.
Well, forgive me for interrupting, Mr. Nelson, but there are two things that I'm trying to figure out. Number one, let me point out the obvious. This case is on a trial calendar because it's a 2022 case that's been pending for a year almost. And it was set to go to trial, and all of the pre-trial discovery deadlines have expired. And so there's theoretically no reason that I can't call this case in, which is the conversation we're having right now. But in reviewing the case to figure out what are the substantive issues involved, I agree with you. And I think I prefaced, and you may not have heard me say that way, because I apologize, Mr. Nelson, I thought you were already here. But I agree with you that, of course, the Superior Court has exclusive jurisdiction over property records, and that to the extent that there was any rescission or adjustment or whatever of any real property records, this court is the court that would have the authority to do that. And then to Mr. Hodges' point, if there were actual damages to be entered associated with his tortious interference claim, that would also be with this court. But if the underlying evidentiary factual issues associated with whether or not these deeds were legitimate, when they were executed, by whom, whether they were forgeries, whether they weren't forgeries, et cetera, and therefore either are or are not part of the estate, if those factual issues are to be litigated in the probate court, then shouldn't the Superior Court sit back and let the probate court do its work?
I would say, I'm sorry.
No, go ahead.
I would say yes, if that is going to happen, and if the court wants to wait until we get through the probate court, I wouldn't be opposed to that.
Okay.
I just don't think that what I heard of Mr. Hodges' presentation is completely accurate. But yes, I would think if we are going to go into the probate court and argue those issues, then wait before we put it on trial over here so we could address the rest.
Okay, Mr. Hodges, what is the status? I know you said you have a conference today, 11, and you believe or are hopeful that that conference will result in a more definitive answer on who is the pending versus the actual appointed administrator.
Correct.
And then what happens from there in terms of the status of the proceedings in probate court?
The administrator then has full power to go after assets of the estate, and these will be claimed to be assets of the estate because deeds would have been invalid. If the deeds were invalid, they never moved outside of the estate.
Right.
And we're in your court. And so what I want in the probate court is to be the administrator. And then if we have a situation where, and again, let me go back to the district attorney. He told me yesterday afternoon, these clerks have said they falsified things. They falsified the fact that the decedent signed the deeds in front of them. The notary.
Hodges, forgive me for interrupting you, but I understand all that, and I will probably be very outraged about that when and if that evidence is presented to me. But I don't think it's necessary for us to get into that for today, because
no, I'm literally thinking let's see how much the probate court clears up today.
Right. Okay. So here's what I think I might do in looking at this based on y'all's announcements. What I think would make sense is a 30 or 60 day stay of this case so that y'all can figure out what the status of the probate court action is. And in 60 days, we will have a status conference. Y'all can tell me what is the status of the probate case, where is it, and is it moving along, or do we want to continue to litigate the matter in this court? Because what I don't want to happen is this case to sit forever without having been moved, because the probate case is not moving in any way. But if the probate case is moving along and these substantive issues are being litigated in the probate case, then it seems to me that it would be to everybody's benefit to save attorney's fees and a headache to try those issues in two different places, to litigate those issues in two different courts, to let the probate court do its work. And then this court, based on whatever the outcome of the probate court is, can take that information and then decide if it results in a requirement that we rescind deeds, or that the court award damages. What say you, Mr. Nelson and Mr. Hodges, on a 60-day stay to sort of figure out how far the probate case is advanced and where we might be at that point?
Your Honor, I'm not an objection to that at all.
Okay, Mr. Nelson?
Sounds reasonable to me, Your Honor, as well.
Okay, well, then that's what I'm going to do. I'm going to stay this case for 60 days. We will enter an order, and what it will say is that at the end of 60 days, the parties need to provide me with some sort of update. It doesn't have to be lengthy or involved. It can be by email. And if we need to have a status conference, we'll have a status conference if there's any updates that we need to discuss. But basically, it will require that if the case needs to continue to be stayed, that y'all need to let me know before that stay lapses. And so that will be roughly, what are we, the beginning of September? So it'll be the beginning of November.
Yes.
And
hopefully we can get back to you even prior to that.
okay, I would encourage that and welcome that to move it along, because I said this case has some age on it. But I don't want to do work that's unnecessary when the probate court can do some of that work, and we'll have to do it anyway. So, okay.
Yes,
Thank
Your Honor.
you.
Thank you both. Have a good day.
Thank you.
Okay. Mr. Chavda and Mr. Thompson, just going to let you know in advance that your matter, I think, is going to take the longest. And so as a result of that, it's going to come at the end. And so it's been about 30 minutes since we've gotten started. I guarantee you it's going to take me at least 30 minutes to get back to you. So if you want to multitask or do other things that you want to do and come back at around, say, 10:45, I think I'll probably be in a position to give you my undivided attention, having dealt with the other matters. So feel free to log off or just mute and come back when you're ready. Okay, around 10:45.
Thank you.
Thank you, Your Honor.
Thank you. Okay, and so Miss Comer. No, not Miss Comer. I'm sorry. Miss Jones, the court reporter.
Yes,
Here's what I intend to do. If you have, Ms. Johns, did you get a court reporter or no?
No, Your Honor.
Okay. Here's what I'm going to do. I'm going to take up the Wycus matter because I think it will be shorter. And then I'm going to take up your matter after that. And as I'm doing that, I'm going to ask Mr. Freehoff to reach out to Ms. Taylor and my court reporter and find out if she can jump on at about 10:15 for 10 or 15, 20-minute hearing. If she cannot, then I'm probably going to go back and see if I can impose on the kindly Miss Jones, to whom I will owe a great favor.
Okay.
I'm sorry, Your Honor. This is
Yes, Mr. Thompson.
yes. With regard to the Patel and Bailey matter,
Yes,
we
sir.
would also like that taken down. So if the court reporter is available, or if Ms. Jones doesn't mind further imposition, with extreme gratitude, of course. We just wanted to make the court aware of that.
Well, you will. Okay, so a couple things. You will need to reach out to Mr. Thompson, or excuse me, to Ms. Jones. No offense, Mr. Thompson, but the only reason that I was negotiating that on Ms. John's behalf is that Ms. John's is a part of the public defender's office.
Sure.
And is pursuing these matters on behalf of indigent criminal defendants who these are appeals. And so there's more of a role for the court to undertake in terms of providing that court reporter service. If my court reporter is available and you want to take that up with her, you can, or you can ask Ms. Jones, but I'm not going to be the negotiator for you on that one. Okay.
Understood. Understood.
Sorry.
Thank you.
Thank you. Yes,
Judge,
Mr. Freehoff.
Before I contact Ms. Taylor, if I'm going to present to her the possibility to take down the Bailey Patel matter, I'm sorry, Stuart Bailey, Manish Patel matter, what's the time announcement I should be giving her?
No, as I just said, if Mr. Thompson wants to negotiate that, he can try and secure a court reporter on his own. I'm just worried about Ms. Johns.
I gotcha.
And Ivy matters.
Okay, all right.
But I do think their announcement, if she were to stick around, I think their announcement was 30 minutes.
All right, I'll let her know.
Okay, thank you. Okay, Ms. Jones, are you ready to go?
Yes, Judge.
Okay, thank you so much for your patience with me. This is going to be a hearing in the matter of Brianne Wykis, W-Y-K-I-S versus Ovation Condominium Association, case number 2021 CV 356-408. Excuse me. As I noted when I was calling the calendar, the reason that we're all here is that this matter resulted in a judgment in favor of the plaintiff. The defendant filed an appeal, a timely notice of appeal, and has been in the process over some months of securing the transcript of that trial in order to complete the record for it to be transmitted to the Court of Appeals. And somewhere along the way, Ms. Wykis filed a motion to dismiss the appeal because Ovation had not filed the transcript. And the court reviewed the Ovation responded, the court denied the motion because the procedural standard had not been met. And then sua sponte filed some variation of an order to show cause as to why I shouldn't grant attorney's fees under 915-14 because the motion for attorney's fees was unfounded, given that a call to the court reporter would have demonstrated that the court reporter was in the process of preparing the transcript, number one, but also number two, that Ovation had been in close contact with the court reporter about determining the status and getting it completed, providing information and finding out when it would be completed, et cetera. Having said that, I will acknowledge, based on the briefing that I asked the parties for in advance of today's hearing, that the defendant's, the plaintiff's position, I think I understand, is that there's no obligation to confer, number one. And number two, if there was a delay, it was Ovation's obligation to file a motion to request additional time to get the transcript filed, which of course was not pending. Having said all of that, here is what I'd like, Mr. Knight, is to get both parties' announcements of who I have on behalf of each of the parties, starting with the plaintiff. And then, Mr. Knight, I'll start with you in terms of why the court should not award attorney's fees associated with the filing of the motion to dismiss. And I guess more significantly, the response to the motion to dismiss, which was lengthy and expensive based on the fee proposals that I've seen. Mr. Knight?
Sure. Good morning, Your Honor. Brian Knight and Lawton Jordan be on behalf of the plaintiff.
Okay. And who I have the defendant?
Samantha Mandel and Michael Kendall on behalf of Ovation.
Okay, excellent. Thank you. Mr. Knight?
Thank you, Judge. You've given a correct summary of this case. As you remember, we obtained a jury verdict back in December 8th of 2022. Your Honor entered a final judgment in this case in January 10th of 2023. There was a notice of appeal that was filed in January 19th of 2023. In that notice of appeal, the defendants requested a transcript. That transcript should have been filed by February 18th, 2023. And so in this case, Your Honor, we filed a motion to dismiss on July 8th. We waited almost 6 months for this transcript. It was not filed. There was no extension filed. And therefore, we filed that motion. Your Honor denied it and sent us here for fees based on 915-14. As you know, 915-14 requires that there's no legal justification. That's not the case here, Your Honor. The plaintiff followed OCGA 5642 and 5639 to a T. There's that requires 30 days to file the transcript. And then if not, you file an extension. None of that was filed. We didn't file this, Judge, on the 31st day. We waited to almost 6 months, and which we'll go through in a second, Judge. There's a presumption here in Georgia that if you don't file a transcript, you don't file an extension, there's a presumption that they should be dismissed. Now it's a rebuttable presumption. You can come back, the defendant can come back and provide evidence that that it was a court reporter's fault for not getting the transcript filed. But importantly, Judge, we're here today because Your Honor wants to know why we didn't contact the other side or the court reporter before filing this. The reason is, Judge, there's no requirement. There's no requirement like Uniform 6.4 rule in discovery where you're required to do it. More importantly, Judge, there's nothing in the statutes that require it, and there's no case law that requires it. If anything, the defendants didn't comply with Georgia law. They didn't comply with the statutes. If they had, we wouldn't be here. We wouldn't have had to file a motion. We would have had notice.
Right, but Mr. Knight, what about the Ovation's position that the burden on the movement is to demonstrate that the delay was inexcusable, and given the circumstances that you didn't have, not only did you not have evidence that the delay was unreasonable or inexcusable, you didn't attempt to get any because, for example, you didn't call the court reporter and say, when was the last time anybody called you? Or when was the last time anybody emailed you and checked on the status of this? Because if Ovation is right, that that's the plaintiff's burden, then your motion theoretically would be unfounded because you didn't have any evidence and weren't prepared to offer any evidence to support your motion.
No, that's a great point, Judge. And that's why we relied on Georgia law, case law. And so in our brief, Your Honor, we cite Dye versus U.S. Bank National Associations. That's 273 Georgia App 654. And in that case, Judge, I'm going to quote, this is a quote, we quote in our brief. It says, Georgia law is clear, however, that any delay in completing the record past 30 days granted by statute is presumptively unreasonable and inexcusable. It goes on to say delay of excess of 30 days is prima facie unreasonable, inexcusable. So there, Judge, that case alone shows that we had legal justification for the motion. But Your Honor, going back to kind of my introduction, just because opposing counsel didn't follow the rules, we shouldn't be punished for this. There is legal justification for our motion. And that's the critical thing that Your Honor has to follow is the 915-14 standard is so high, you have to show no legal justification. We follow the statute. We follow case law. On the other hand, the defendants are trying to make up their own law, that there's some kind of requirement that plaintiff calls a court reporter. I think the judges is just in line with a default judgment, a failure to file a motion for summary judgment, a failure to respond to a request for admissions. That you don't have to do 6.4. You can a complete failure to respond to discovery. You don't have to go there and say, hey, are you guys going to file that answer to my complaint? Are you guys going to file that response to my request for admissions or a contempt motion when there's an order that's violated? You don't have to go there and say, hey, you guys going to comply with this order? You don't have to do that, Judge. And there's no case law, nothing that would support that position. But Judge, as I mentioned, 915-14 has a high burden. We cite Shane Tyler versus DeKalb County employees in our brief, which states the relevant question is whether some authority arguably supported plaintiff's position. And I think with the statutes and the case that I just cited, there's at least some authority that supported why we filed our motion to dismiss. OCGA 5642 requires 30 days to file the transcript. OCGA 5639D says if you don't file it within 30 days, you must file before the expiration of the period a request for an extension. That was not done. There's a reason for that. It's to let everybody know, listen, there's an extension, but it also lets people know when this court reporter is going to get the transcript. We're sitting at 9 months here, Judge, and we still haven't even seen, the other side hasn't even requested an extension from you. Which I assumed would have been done after all of this, and at least told us when this transcript was going to be filed. But going into the presumption, Judge, I've already cited the Dye case for this presumption that we had going into this. Granted, it is rebuttable. And I agree with Ms. Mandel that her conversations with the court reporter probably do meet that rebuttable presumption. But we also cited cases, the Gilmore versus State 127 Georgia Act 249 case that states that since a delay was not attributable to counsel, but to the court reporter, they should be excused for failure to file an appeal should not be dismissed. But it goes on to say this contention has been expressly rejected by both the Court of Appeals and Supreme Court. And so this idea that just because the court reporter is at fault and you don't file an extension doesn't mean you get an automatic get out of jail free card.
Right. I mean, I don't disagree with you, but that's because in those cases, the whole point is it was incumbent upon the attorney to continue to communicate with the court reporter and say, where's my transcript? Where's my transcript? Where's my transcript? But that's not what we have here, right? I mean, Ms. Mandel and Mr. Kendall were in pretty consistent communication with Ms. Taylor back and forth about here's the status. Can you make these corrections? Can you tell me what these words are? What citations you did, that sort of thing. And I agree with you that you were not affirmatively obligated to reach out to opposing counsel. But if the issue is the transcript, the court reporter is equally available to both sides since you both paid her for takedown. Granted, you don't have any interest in necessarily generating the transcript if you don't have an appeal. But you certainly had access to contact her and find out what the status was.
And I acknowledge that, Judge. And I think that, maybe the reason that we're here today is, I don't know if you noticed, but we weren't on any of those emails over those months of conversations. I think you're right. If I'm on those emails and I'm getting those emails, and I know for 5 months Ms. Mandel's working on that, I get that, Judge. But that wasn't the case here. I was on 0 emails. So you can imagine from my position, I'm like going 6 months. Clients on to me, I don't know what's going on, and I'm reading the case law that says 6 months is deemed we had case law that says 6 months is deemed unreasonable as well. So that's why we moved, Judge. And getting back to that, I still question why there was emails with the court reporter without me being on that. This was your court reporter, Judge. This was not a third-party court reporter. I believe that court reporter is part of the court, just like judicial assistants and everybody else. I should have been on those emails. I believe that constitutes ex parte communications. I know that's a gray area, but I always put them on there. I always put opposing counsel on for court reporters, judicial assistants, anybody that's part of your team. And I think that if it had been, this would be a different situation. I just didn't know. I get, Your Honor, that maybe that you want me to go talk to the court reporter, but I'm zealously advocating for my client. And this is an adversarial relationship. And I wouldn't do that in a default judgment. I wouldn't do it in a contempt motion, and I wouldn't do it here, Judge. But with that, Ms. Mandel has an obligation because the statute's clear. It says the duty is on the appellant to get the transcript filed. When that happens to me, Judge, I am going full bore to get extensions, letting the other side know of what's going on, because I've seen courts dismiss appeals, even with trying to get the court reporter, even with the court reporter issues based on this length of time. But Judge, as we go in, that deals with the 915-14, Judge. There is adequate law to give us cause to file a motion to dismiss. But going on to your point, which you stated in your order, is that we should have contacted somebody before filing the motion. Judge, as I mentioned, nothing in the statutes require that. There's no uniform Superior Court rule like Rule 6.4. There's no case law. If your judge decides to sanction us, you would be doing that without any legal authority to do that. Like I mentioned, this is an adversarial relationship, and I didn't know about the conversations. And I think that you can acknowledge that if I was a part of those emails, I can see your point that may be a different situation, but I wasn't on any of them. And therefore, there's no legal justification to warrant 915-14. If anything, the defendants didn't follow the statute, didn't put me on the emails, had ex parte communications with your court reporter. They're the ones at fault. I shouldn't be sitting here in this position. But with that, Judge, if you decide to issue sanctions, the fees that they propose are 13 hours of time spent, $5,500. Our motion took about an hour to prepare. For her to just attach a couple of emails with the court reporter shouldn't have taken more than an hour. But with that, Judge, one thing that the defense is going to argue on the default judgment example, I noticed in the reply brief, is they say the default judgment is different here because default judgment's automatic. That's not the case. The Bowen versus Savoy Supreme Court case, 308 Georgia 204 2020 case, said that there's no more requirement for reasonable explanation like the old days. Now it's just showing a proper case. So you don't have to have any justification anymore because that third prong for default judgments, the proper case is kind of taken over. And so her analysis on default judgments don't apply here. But Judge, for 8 reasons, you shouldn't grant 915-14. We followed both statutes to a T, which evidences legal justification. We have defendant violated both statutes by failing to get an extension. We shouldn't be punished for that. Plaintiff had a presumption that it was reasonable and excusable based on Dye versus U.S. Bank. We cited Meltzer versus Seabuck. We cited Baxter versus Long and Farrig versus Garrett, all in our brief, Judge. Defendants don't dispute any of the case law, don't dispute the statute. There is no dispute. They haven't cited any legal authority to state that I had an obligation to contact anybody. So there is legal justification, which is undisputed. And again, plaintiff shouldn't be punished for defendant's negligence. Thank you, Judge.
Okay, thank you. Ms. Mendel?
Your Honor, my position's set forth pretty clearly in the briefing, and I'm not going to repeat it all, but the long and short of it is that plaintiff's counsel is focusing on the wrong statute. OCGA 5648 CNF make clear that the appeal can only be dismissed when there has been an unreasonable delay in the filing of the transcript, and it is shown that the delay was inexcusable and caused by me. That statute is what controls and what governs the right to have a dismissal. And the statute that plaintiff is relying on does not address the right to a dismissal. And that's the crucial distinction here, is that this statute controls, and as plaintiff acknowledges in her briefing, that this burden must be met, and that the failure to file the transcript alone is not legal reason. The Gilmer case that plaintiff's counsel is relying upon, there's a pretty obvious reason why that case has not been cited since 1975, and it's because of these statutes that have come into play. That's not good law. And so to rely on that is itself frivolous to justify a frivolous motion. There's a couple things about, just in response to what was just said. The default judgment standard that Mr. Knight was just talking about is not the point. Like, a default is automatic, and that's why there's no duty to confer. A failure to respond to discovery does not justify anything automatic. A insufficient discovery does not justify anything automatic. That's why there's a duty there. But here, the statute makes clear that the failure to file the transcript alone is not enough. And what makes this more egregious is that in plaintiff's motion, not only did they not try to get the evidence to support it, or offer any evidence to support it, but they represented affirmatively that, quote, Ovation failed to exert any effort to perfect the record on appeal. So they affirmatively told this court that we didn't do anything, but they didn't actually go to look, and it would have taken a phone call to me, to Ms. Taylor. Any just basic diligence would have gotten the facts that would have shown that this motion was frivolous. The ex parte notion is kind of beside the point, but that's not the law. I was not communicating with Your Honor without counsel involved, and the crux of it is that if we're making a big to-do about statutes, we should look to the one that applies and what governs the right to dismiss. And that statute makes clear that what showing needs to be made, and no effort was undertaken whatsoever to make the showing. I think plaintiff admits in the opening brief that even if we had done it now, it would have been too late, which sort of begs the question, then there was no strategic advantage to not asking. It wasn't like it could be like a big gotcha, because per their own argument, it would have been insufficient Had I done nothing up to that point, then trying to do something then wouldn't have fixed it. So there was literally no reason for them to go forward and file a motion. To the extent that plaintiff believes I took too much time responding, well, it's a pretty big ask, and one that would be highly prejudicial to my client if I lost it. I had a months and months and months of communications with Ms. Taylor to call through and put together a detailed affidavit, and I went through all of their cases to make sure that I hadn't missed something, and none of them apply. You know what's different in all of their cases compared to this one is all of them turn on facts, and plaintiff presented zero. There is not one iota of factual support for the relief sought, which is pretty grand relief to seek just on a wish and a prayer and a representation that I didn't do anything, when in fact there's hundreds of pages of emails showing just the opposite. The suggestion that well, he didn't know about the communications with Ms. Taylor, and that's the point, is he should have learned them before jumping the gun and coming to this court asking for fairly extraordinarily relief on a issue that was frankly there was no basis for it, and the statutory law is pretty clear. The overruled case relying on an outdated statute that doesn't apply here obviously is not justification, and that's sort of the only law that's on point that would justify going in there blindly, and that law is not good law. So Gilmer doesn't rescue this in my view, and I believe that's all that I have. The rest of my argument is pretty.
Judge, can I just have a quick rebuttal for the record?
Yes.
Judge, Gilmore case was in 1975. However, Dye versus U.S. Bank was a 2005 case. And Dye versus U.S. Bank, that's 273 Georgia App 654, held Georgia law is clear. However, that any delay in completing the record past the 30 days granted by statute is presumptively unreasonable.
Actually, forgive me for interrupting you, Mr. Knight, but I think you got that citation wrong. Maybe there's a typo, because when I pull up 273 Georgia App 654, it gives me Green versus State, which is a criminal case.
It's 652, Your Honor.
Thank you.
Oh, sorry about that, Your Honor.
That's okay.
But again, 2005 case. And then also Kelly versus Dawson, which we cite in our brief, 282 Georgia Supreme Court case 189. It's 2007 case, which quotes as a delay in excess of 30 days is prima facie unreasonable and inexcusable. Therefore, Judge, we had reason to file this. We had, at least legal justification, which would not warrant 915.14 attorney's fees. Thank you, Your Honor.
Okay. Well, so I started this whole thing, and I really try not to lecture because all of you are been practicing at least as long as I did, if not longer. And y'all know how to do your jobs, but sometimes it is nice. I keep hearing you tell me what the law is and what this is, and there's no law that requires me to do this. But, I understand that the rules of professionalism have not been enforced in quite the same manner, but you guys keep talking about defaults. I mean, when I was a civil defense attorney, and I was going to move to open default because I realized a client was in default, I would get my stuff together. But the last phone call I made before I filed all that stuff was, I'm going to file a motion to open the default. Are you going to consent? Because the judge is going to let me out. And what I hear from both of you is, Mr. Knight, you never picked up the phone and called the court reporter and said, what efforts have been made to get the transcript? And Ms. Mandel, when you spent 13 hours and I will note, they filed that motion, and like a day and a half later, you spent 13 hours. I think it was the 13 hours immediately after receiving the motion, because you filed, I think, your response the next day. At no time did you pick up the phone and call Brian and say, what are you doing? Why don't you withdraw the motion? This is ridiculous. Here's all the emails. And you can say, Ms. Mandel, that that's not your obligation. And you're absolutely right. I think Mr. Knight is probably correct that his obligation doesn't require that he contact you, but that doesn't mean that the rules of professional conduct of us as lawyers and being civil and moving the case forward and not wasting each other's time and the court's time with motions that are not well-founded, and 13 hours of your time, Ms. Mandel, with response briefs that could have been avoided. That is ultimately why I entered the order to show cause, because I was so frustrated. I remember this trial. It was hard fought. The parties litigated aggressively. And I was frustrated with both the parties, particularly Mr. Knight, with your side, admittedly. At the end of the day, I feel like all of this results in this. Unfortunately, I completely agree with everything that Ms. Mandel said, but unfortunately, I think the case law is right, that there is not a legal basis for me under 9. I don't think it rises to the level of 915-14. So hopefully, having to listen to me nag and lecture, and also the time that Mr. Knight must have spent preparing for this hearing is a sufficient pound of flesh to remind both parties, particularly Mr. Knight and his colleagues, don't pull the trigger on motions until you know what the lay of the land is, because it's a waste of everybody's time. And it doesn't sit well with the judges that we have to deal with. Your motion, which was prepared in 30 minutes because you didn't call, maybe an hour because you didn't call the clerk, the court reporter, and Ms. Mandel's 13-hour, 100+ page of email attachments. All of that was something the court shouldn't have had to deal with, and that neither party should have had to deal with. And I'm the one that opened the can of worms. I am not going to award fees against the plaintiff under 915-14. But as I said, perhaps the punishment is having to listen to me blather on to you in a way that y'all shouldn't have had to listen to, number one. And number two, whatever time you spent, hopefully you'll think twice, Mr. Knight and your colleagues, before pulling the trigger on a motion without checking on what the status is and whether or not opposing counsel has been doing their job. I don't expect you to lose strategic advantage, but I don't think this is one of those situations. So that's my nag. I apologize, Ms. Mandel and Mr. McKendall, for the effort that you put in to prepare. But unfortunately, I do think that Mr. Knight is right, that legally there's not a basis. This does not rise to the level of 915-14, but that doesn't mean it makes the court any less unhappy. Okay.
Well, Judge, I hear you loud and clear. So with that, can I address two small things so we don't waste anybody's time?
Sure.
In this case, does Ms. Mandel have any clue when this transcript is going to be ready or when it's been indicated?
Nope. I'm waiting on the last day.
Right. So my understanding is that the trial transcript is essentially in review, I think was the last email that I saw.
Oh, great.
But that there was upon review, it was determined that there was another hearing that we had that was taken down that had not been transcribed.
Okay.
And that when all of those are done, Ms. Taylor will file them. But this case is part of the reason that Ms. Taylor is not currently taking down civil cases, because we have such a high demand for turning around the criminal cases under the Supreme Court's Rule 39. So this is a priority for your clients, and I don't mean to dismiss it as not being important, because you're right, your clients have the right to vindicate their issues in front of the Court of Appeals just as much as anybody else. But in terms of priority, we have to prioritize those who are in jail and prison to make sure that their convictions are legally justified. So that's part of what the delay has been. But I do know that Ms. Taylor has been working diligently. Ms. Taylor, do you, since I do have you on the record, do you have any idea of when you think the transcript will be ready so that the parties can be aware of it?
Sure. Ms. Mandel has up to volume 4. You should have that, right? That's the last volume. I'm working on the exhibits. I don't want to do the exhibits yet because I'm working on that post-trial motion.
Right.
And I was actually proofing it when you called me. So you'll actually have it by tomorrow. And I'll have the exhibits. I'll work on them over the weekend, hopefully by Friday, but not to make any promises. Definitely over the weekend, Monday, you'll have the exhibits, the volume of exhibits, and then I'll be done.
Okay.
And then the second thing, Your Honor, is, originally we asked in a motion for supersedeas bond a year. We're going to go well past that now. We're already at 9 months. Would the court entertain an amended motion for supersedeas bond to extend that time period out?
Well, I'm not going to prejudge it, but certainly if you file it, I'll hear it. I don't know what the circumstances are. I don't know the ability of Ovation to simply extend the bond that they've already purchased, or how that bond was generated, if it was purchased or if it's, being guaranteed by Ovation. I don't know any of those facts, but certainly if that's something that you are concerned about, and after discussing it with Ms. Mandel, are not reassured that their bond that they've already purchased or whatever they've done would continue in place to protect the potential recovery of that judgment is not sufficient, then I'll hear it.
Well, I will definitely talk to Ms. Mandel before I file any motion. I'll tell you that much.
Thank you. I appreciate
Thank
it. Thank you all. Have a good day. Yes, Ms. Mandel, did you have anything else?
Nope.
Oh, okay.
I
Have a
have
good day.
Is it gonna be shared takedown?
I'm sorry, Ms. Mandel, Mr. Knight, was that shared takedown or?
No, Your Honor.
Okay,
Okay,
Mr. Knight,
thank you.
We'll take it, Your Honor.
thank you. And Ms. Jones, I don't know, but Ms. Mandel, Mr. Kendall, Mr. Knight, y'all are free to be excused. Thank you for your
Thank you.
time and listening to me lecture.
Thank you, Your Honor.
Ms. Jones, have you been retained to stay on with Mr. Thompson or the Patel versus Bailey matter?
No, I have not.
Okay. Well, then my court reporter has joined us for the pro se, not pro se. The indigent criminal defendants in this case. And so I believe that I appreciate very much your willingness to stay on with me and provide that accommodation, but I think you're free to go.
Okay, thank you.
Have a good day, Ms. Jones.
You too. Bye-bye.
Okay.
Judge,
Yes.
I believe Ms. Taylor is going to have to address some billing questions before we get underway with the Anthony Ivy or Riddick matters. So I just wanted to bring that to your attention so she didn't.
Right. She texted me.
Okay.
So, question, Ms. Johns.
Yes, Your Honor.
Is there, other than the indigency, is there typically in a traditional criminal context with indigent defendants, we would provide a copy of the transcript. But since that's not the traditional construct that we're in, is it typically that your office would be paying for the transcript or paying for takedown and transcript if necessary?
Yes, Your Honor.
Okay. And so if that's the case, can Ms. Taylor get your information so that she can email you a bill and you'll get that taken care of for today's takedown?
Yes, Your Honor.
Okay. Ms. Taylor?
Yes, Judge. Can she send it to Mitch, and Mitch can send it to me in an email form?
Okay.
If she sends a chat, I can't read it.
Oh, yeah, no, yeah, that's fine. So Ms. Johns, if you will
email me directly. Mhm.
right, if you'll email that to Mr. Freehoff, we'll make sure that it gets to Ms. Taylor.
Will do. Thank you, Judge.
Thank you.
Thank you. And Ms. Comer, does the city want to share and take down?
That's fine.
Okay. So yes, Ms. Comer, if you will also please email your contact information to Mr. Freehoff, assuming that we don't already have it. So that Ms. Taylor can send you an invoice, and I'll just ask that you guys, it should be a pretty low invoice if you'll just make sure and take care of it pretty quickly.
Ms. Comer, do you need my email address?
I do. And I'm thinking we probably don't, I think that it's fine if we don't have the transcript. So I think we're fine. Thank you.
Okay. Well, that'll be fine then. Thank you, Ms. Comer. I appreciate that. Okay. So Ms. Taylor, are you ready?
Yes, Judge.
This is going to be a hearing in the matter of Arian Riddick, AIRIAN RIDDICK versus Christopher Ward et al. Case number 2023 CV 377649, and also case number Anthony Ivy, that's IVEY versus Judge Ward et al. Case number 2022 CV 371814. Now, I've called both of these cases together to the extent that we need to distinguish between them. I'll ensure tell the parties, hey, listen, tell me that we need to distinguish between them. But as I understand the positions procedurally of these cases, is that the magistrate court allowed for a bind over of these cases to the state court. And the circumstances of that bind over are challenged by Ms. John's clients, Mr. Riddick and Mr. Ivy, in reliance on, we had a series of these cases. I know this case, particularly the Ivy case that was already pending, was stayed to allow resolution of the Paris versus the City of Atlanta case, which essentially, the facts may, differ, but essentially had the same fact pattern, which is a bind over to state court. And there's a challenge that the magistrate court either lacks subject matter jurisdiction over the charge, or that in the absence of a finding of probable cause on the bound over charge, the magistrate court was not authorized under the current standards to bind over those charges. And so where I believe we are, and that's when I'm going to throw it open to you, Ms. Johns and Ms. Comer. And actually, I think I'm going to start with Ms. Comer, because I think on both of these, the notice that I sent out was to ask the City of Atlanta to tell me why you don't think that the Paris versus the City of Atlanta case was dispositive of these, and would require the dismissal, the reversing of the, y'all have to tell me procedurally what it would be that I would be doing, but I think it would be reversing the magistrate court's order that bound the case over to state court, which would either have the effect of meaning there would be no longer a charge against the individual defendants, or that only that lower charge as it was originally charged in magistrate court continued to exist. I think that's where we are procedurally. Yes, Ms. Johns?
And just because it matters in this case, it's the municipal court, not the magistrate court.
I'm sorry.
And the jurisdiction matters.
And you're right, it does matter, and that's my fault. Obviously, I deal much more on an interface with the magistrate court much more frequently than municipal. So everywhere that I just said magistrate court, please forgive me. That was intended to say the word municipal court. I'm sorry for that. And thank you for that correction, Ms. Johns. Ms. Comer, what is the city? I know I've read your briefing. I know that the city has outlined in writing why it believes it can distinguish. But can you just sort of address for me in short terms because let me say this, as I look at these two cases, it seems to me that the city wants to focus on this idea that the ruling would, perhaps that Paris versus City of Atlanta, that it limits the ability of the municipal court to, it unfairly limits the authority of the municipal court, and that these are things that they do all the time. In terms of binding cases over to state court, but that the real issue is that these particular cases seem to be happening in a situation where there's some additional showing of probable cause, an additional element perhaps of the crime or something like that, that's not being satisfied in the municipal court before it gets sent over to the state court. And to me, that seems to be what the sticking point is. Can you address that for me, Ms. Comer?
Yes, and Judge, I'll kind of start with the Ivy case because it's a little, it's the same thing, but a little different. So basically in the Ivy case, we received a citation and the petitioner was charged with the city ordinance charge. But after reviewing the citation, reviewing the police report, getting a report from victim witness, we felt as though it was appropriate to amend the city ordinance charge to a state misdemeanor charge of simple battery. And then we motioned the judge to bind the case over to the court with the proper jurisdiction, which is the state court. Right. So we feel as though Paris kind of affirms what we did. We feel like
I agree with you, Ms. Comer. I agree that Paris affirmed the right of a municipal court to bind cases over to the state court. But that's why I went to that issue of probable cause, right? Because if it was the original charge recast in a way that did not require additional showing of facts, then I would agree with you that the case just goes straight to state court and state court charges it as the highest crime that it can be charged as. But as I understand, particularly Ivy is the one where the allegation of the original citation was some sort of biting or hitting in the face that resulted in like broken skin. And as I understand Mr. Ivy's position, it's that exactly begs the point of this probable cause issue, because the citation that was issued says somehow resulted in harm. And as we all know, simple battery, even simple battery at the state court level, requires a showing that the contact was intentional. And if the citation doesn't contain that information, then isn't Ms. John's position right as to Mr. Ivy? What do we do about that additional element that's required?
And Judge, with regard to the probable cause, we feel as though since most of these defendants have made bond, that a waiver of bond waives the preliminary hearing for a probable cause hearing. So one case that I cited in the brief was Watts versus Pitts, which states that a person who is arrested and released within the time prescribed by law on an appearance bond is not entitled to a commitment hearing. And then another case, State versus Gilstrap, posting bond constitutes a waiver of the right to a preliminary hearing. So we feel as though the petitioner or the defendant waived their right to a preliminary hearing. So it was the duty of the municipal court to go ahead and bind this case over automatically.
Right. But at the time he waived his right to a preliminary hearing, right, he was only charged with a municipal court charge. Right. And that charge was supported by probable cause as demonstrated by the citation issued by the officer, right?
Right.
And so my question, even though I agree with you that that statute case law that you're relying on, obviously somebody who gets out on bond may not necessarily be entitled to a preliminary hearing, but how can you waive preliminary hearing showing of probable cause on a charge you haven't yet been charged with?
Well, we did technically. So we amended the citation to a simple battery. And this kind of gets into what a court of inquiry is, which I'll kind of go into next. Paris did also confirm that a municipal court can serve as a court of inquiry on any crime, which will be the simple battery. So once I amended the citation to simple battery, the judge acted as the court of inquiry. He read the defendant the charge of simple battery. He arraigned the defendant on that charge. But if we look at OCGA 17-7-23, it states that the duty of a court of inquiry is simply to determine whether there is sufficient reason to suspect the guilt of the accused and to require him to appear and answer before the court competent to try him. Whenever such probable cause exists, it is the duty of the court to commit. If the defendant is no longer in custody and has made bond, as in this case, we feel as though there's no right to a preliminary hearing. In Paris, the court failed to act as a court of inquiry because the judge dismissed the accusation before the court could even act as the court of inquiry. We feel as though in Paris, the municipal court didn't even understand if they could act as a court of inquiry or what that looked like. But we feel as though in this case, the judge definitely acted as the court of inquiry. As I stated, he read the defendant, the new charge that we amended to, which was the simple battery. He set bond, but actually allowed the defendant to stay on the same bond. He, in the order which binds the case over, like the bond over slip, in that there is a statement finding probable cause. So we feel as though in this case, unlike Paris.
Right, but the court wasn't given any evidence, right? So how could the court have found probable cause that the injury was intentionally the strike, the whatever was intentional rather than somehow accidental, unknown of its cause? And I think that's what I understand Ms. John's position to be, is that even though it looked a lot like a court of inquiry, because I am telling you what your charges are, I'm arraigning you, I'm allowing you to enter a plea, I'm doing all these things. How would I legally be justified in finding probable cause if nobody ever gives me any evidence from which I can make a finding of probable cause?
And we feel as though the judge didn't have to technically make a finding of probable cause since the defendant waived that right, which goes back to those two cases where if the defendant has made bond, then technically they don't have a right to a probable cause hearing. And the judge therefore bound the case over right away to the court competent to try the defendant. Now that is discretionary. If the judge decided to have a probable cause hearing, he could have did that. But technically the petitioner had no right to the probable cause hearing because they made bond. And I feel as though that's kind of the main thing, for us, is that she made bond. So she had no right to a preliminary hearing. Posting a bond constitutes a waiver of a right to a preliminary hearing. Also, another case that I'll bring up that's more recent is another case that went up to the Court of Appeals, Anita Taylor versus Ward. And basically, this was the same thing. The city solicitor, we amended a city ordinance to a state misdemeanor charge. It got to the Superior Court level. The judge found in favor of the city. Then the public defender appealed it to the Court of Appeals. And the Court of Appeals recently, as of August 22nd, 2023, dismissed their appeal. And basically, it says that petitioner appealed and the Court of Appeals dismissed their appeal, stating, upon consideration of the entire record, we conclude that this case is not appropriate for interlocutory review and that Anisha Taylor's application for interlocutory appeal was improvidently granted, and we dismissed this appeal. And those kind of were the same circumstances. So in that case, the simple battery charge is still there. The Court of Appeals dismissed their appeal. So it just shows that the municipal court prosecutor and the judge were doing the right thing. We're acting as a court of inquiry. However, when the defendant waives that right by making bond, they have no right to a probable cause hearing. So that's kind of what we would argue.
Okay. Anything else before I call on Ms. Johns?
That's mainly it for the Anthony Ivy case. I would say for the Riddick case, that case is a little different. In that case, we received a citation for a state misdemeanor charge of obstruction. We don't have jurisdiction, obviously, to have a trial in that case. So in this case, unlike the Ivy, we didn't amend the citation. We didn't amend an accusation. We simply, motioned the court to bind this case over to the proper jurisdiction. So that case is a little different because we didn't make any changes. We got the ticket, we realized we don't have jurisdiction, and we asked the judge to bind the case over. To us, it doesn't make sense for us to have dismissed the citation. Like I said, we didn't make any changes. We just motioned the court to bind this citation over to the proper jurisdiction. And I had a similar case like this not long ago in Superior Court in front of Judge Whitaker. And she too felt that that was okay, that, since we don't have jurisdiction to have a trial here, since we're not making any changes to the citation, we were authorized to motion the court to bind that case over to the proper jurisdiction.
Okay, and quick question before I call on Ms. Johns. In that particular instance, in the Riddick case, how does that happen? Is that just an error by the officer, or because obviously you can't charge obstruction with a citation.
Right. Well, it has to be an error on the officer, like filing it in the wrong court. He should have taken it to state court. And this happens a lot too. So when we see those citations, automatically, we just tell the judge this needs to be bound over to the proper court.
Okay. Thank you, Ms. Comer. Ms. Johns?
Thank you, Judge. I'm not quite sure where to start, but I want to address the Taylor case. I think that's
you don't have a citation for that?
I don't, because I don't think that it's relevant. Ms. Comer may, though.
Ms. Comer, do you have one?
The thing that I have the civil action number, but then the appeals is A23A1386. That's what was listed on the
okay, so there's been a decision, but it may not be
not a decision
ripe yet
on the merits, Your Honor. And I just want to address it because it's really a procedural. I can't imagine a universe in which the court would issue a decision laying out its thoughts and its reasoning and its legal analysis in one case, and then deny an interlocutory appeal and intend for that to undo everything in the written decision, which is, I think, what opposing counsel is suggesting the Court of Appeals is done. And when the Court of Appeals issues an order denying an interlocutory appeal, they don't always explain. But I'm going to go out on a limb and just explain to the court that in that case, when the court granted the appeal, so you file for permission to file the appeal, and they issue an order saying yes or no. And in the Taylor case, the court said, yes, do that. And also, we would like for you to address an issue of service that occurred in the underlying certiorari matter in the in the Superior Court. I have always understood that improvidently language to mean that when everything was said and done and the parties briefed that service issue, the Court of Appeals looked at that and said, well, as of last month, this question is no longer relevant because we're operating under new law procedurally. So, and this case is not that different from Paris. So there's no real motivation for us to spend a lot of time answering what, in my argument, my opinion, would be a question of law under the old certiorari procedure that was never addressed in case law that I could find anywhere. And the Court of Appeals just didn't feel it was relevant to go into that, to either agree with us that Taylor was positioned much like Paris and should have been decided in our favor, or to disagree with us on some. But in any event, an order denying an interlocutory appeal is not a substantive order saying that they got Paris wrong, or it doesn't do more than that. And I don't have that case in front of me, but I'm happy to provide the orders that were issued out of the Court of Appeals after this, if the court is interested in seeing them, because that's really all it says. I think in both the Riddick matter and the Ivey matter, well, let me start with Riddick just to try to stay in order so that I'm not completely incomprehensible. But in the Riddick matter, the court previously mentioned that you wanted the parties to tell you exactly what we wanted you to do procedurally. Is this just a reversal? Is this a dismissal? What does this look like if you give us what we are asking for? And under the old certiorari law, 5414B, this court has the authority as a supervising entity over the municipal court to finally resolve the case, which in the Riddick matter, I believe I would argue that just reversing the order denying our motion to dismiss for lack of subject matter jurisdiction would be appropriate. The case should have been dismissed. And in terms of the order finding cause to bind the case over, reverse and dismiss that order on the on our argument that the court had no evidence before it on which it could base a determination of probable cause. Does the court have a question?
I do. Thanks
Yes.
for reading my face. I always hate to interrupt when you're on, I always try to find a wait for a breath. Here's my question. I think you could probably tell from my questions to Ms. Comer that I think that you have a much stronger case on Mr. Ivey's behalf, and that I don't see how you could essentially distinguish Ivey from the Paris case. I'm not sure the same is true for the Riddick case. I mean, the Riddick case seems fairly straightforward exercise of, no, this is in the wrong court. We're going to send it to the right court, and nobody's exercising any prejudgment or adding anything without evidence to the original citation as it was charged.
Yes, Judge. And I was thinking about this in preparing for this hearing because, one of I think the differences, I've had the pleasure of practicing in the Superior Courts of the state of Georgia before as a public defender. I'm aware that the Superior Court is a busy place. And I'm aware that when I was practicing as a public defender in felony court, we never once thought about where I'm at right this minute. The difference is really that the municipal court, this is what we do every single day, right? So whereas, I think if we are dealing with an appeal after conviction and the question is, was there a probable cause? That's harmless error. There's either a conviction or there not. It's an entirely different standard, and it eliminates the need to review this. And there's a question of a lot of questions like that, but at the end of the day, in the municipal court, the only way that a city ordinance, so the first question that the court really should look at is whether the person, the individual, the defendant, Ms. Riddick in this case, on that obstruction ticket was properly before the court, right? She was improperly before the court because she was before the court on process that was not legal. That citation didn't serve to do anything that the judge in the municipal court could respond to in any way, even if opposing counsel is correct, and we were at a court of inquiry. There is nothing on the face of that citation for obstruction that the judge may look at and say, oh yeah, that attestation is sufficient to allege an obstruction, and this is in the wrong place. So I'm going to put on my court of inquiry hat and I'm going to bind it over. That doesn't happen here. In the same breath, obviously, I think all the parties concede that the court may not operate as a trial court. So it's not just the issue that an arrest citation doesn't support a charge of obstruction. It's also, even if it did, the municipal court judge as a trial judge can't do anything. Where we are is that the only way to get a case, when we're looking at a prosecutor who has the legal authority of a municipal court prosecutor, which is different than the Gilstrap case, which I think was the district attorney, which is different than the Watts case, which was a solicitor in the state court. This analysis is over a prosecutor who has very limited authority. That authority to charge is tied to the jurisdiction of the municipal court. You find that at 15-1896, where the law limits their authority to charge. And because they don't have the authority to charge, to move a case from the municipal court, if what we're doing is not dismissing the case and making a phone call to the solicitor down the street saying, I got something I'm going to send you, you should really think about accusing this. If what we're going to do is use the court, then we're relying on a judicial determination of probable cause. That's the only way to move it over. That's the way it has to happen in the Ivy case, where we start with an ordinance and it is turned into a misdemeanor over which the court lacks jurisdiction, and therefore the prosecutor has no authority to charge under the law. Yes.
Right, but the distinction here is that, as I think is discussed in the Paris case, the real flaw in what the municipal court did in the Paris case, and I think what they did in the Ivy case, is that there were additional factors, additional evidence that would have been required to demonstrate probable cause over the charge that would be charged in state court. And there wasn't any, because the court didn't hear any evidence. No evidence was offered. There was no probable cause as to one of the critical elements of that charge, which meant there was no probable cause. Here, the court isn't it's not that there's a lack of evidence. It's that it's a charge over which I have no authority. And so I'm going to transfer it to the court that has the authority and let them exercise the inquiry or consideration of whether or not there's sufficient probable cause for this case to go forward. Why isn't that a distinction with a difference that matters here?
Yeah, it matters because the court didn't transfer it. So in this case, there was the order specifically says the judge made a determination of probable cause and the evidence is devoid. I'm sorry. Are we talking about
Riddick?
In Riddick, yes, right.
Okay, thank you. Just making sure.
Ivy aside, if it sounds like the issue.
No, and that's what I wanted you to do. So I just wanted to make sure you're focusing on Riddick.
So in Riddick, the order that I'm asking the court to reverse is the order where the judge says there was probable cause to bind the case over. There is nothing in the record that demonstrates probable cause. The next question the court may have is, why does it matter? Because it's all going to get sorted out in the wash anyway. A transfer of determination.
You did correctly read my mind. That was going to be my question, because I think, as you referenced a moment ago, let's face it, particularly in municipal court, because of the sheer volume and speed with which they are processing these cases, they have prefab order templates that the judge, I guess my point is, if there was a transcript and I could go back and read it, I will guarantee you that the judge didn't actually say or determine that there was probable cause. What the judge basically said was, this case needs to go to state court because it's not an offense over which we have authority. And that's the order they had in place.
I don't want to speak for the judge without having the transcript right in front of me, but I will say this is not the first time we've argued this. It's not the first time I've disagreed with Ms. Cromer. It's not the first time I've disagreed with Judge Ward. It's been fleshed out. I at this point, if the argument is not clear, then I don't know what to do. But in the Riddick case, it matters because we are solely operating in a municipal court. And it is a very high volume court, and the process matters because it is not unusual. And this is the reason why we have so many pending cases dealing with this issue. It is not unusual to have a defendant come back and forth for trials and everything else. I mean, just multiple resets to then all of a sudden turn around at what is supposed to be, in this case, an arraignment date or a trial date, and then all of a sudden in the middle of court with no notice have somebody not the defendant decide that we're just going to bind it over, and it is confusing. That is happening. It's happening multiple times a week. I would hazard to guess it happens hundreds of times in a month. If it were just this one case, it might not be worth arguing over this one thing. It is that there, especially since Paris, we have a very clear ruling that if you're going to operate as a court of inquiry, this is how it is. This is what the law says. This is what the rules require. And so the difference between the language matters. And I will concede in Riddick, it matters less than in some of the other cases I have where, I have one defendant who is under a bond condition not to possess a firearm, but otherwise everything else is the same. It matters because when these cases go this way, these defendants believe that they are attached to the court and they are under these orders to do one thing or the other. So I would first argue that it matters because that's what the law says. The law says a judicial determination of probable cause is what moves it over. And Paris says that judicial determination must be based on some sworn evidence. And there is nothing that opposing counsel can point to in Riddick that gets us around that. It's just the question of why are we arguing over this? I have the same question since Paris has come out. I feel like both of these are squarely within the universe of Paris. Paris decides these cases. And I'll leave it at that. If there's anything I haven't addressed,
I did have one question. So if I follow your logic in the Riddick case, so and I think it was in response to a question that I asked, but so is the answer that Judge Ward can continue? He was free to transfer the case to state court.
Yes.
But that the order binding it over contains within it implicit or explicit substantive findings relative to the charge that he doesn't have the authority to grant. And so the reason I asked that question is setting aside the particular issue here in this case.
Yes.
If I were to reverse the case, could it go back to Judge Ward and he could just enter a transfer order transferring it to state court? And what would that affect in the Riddick case only? And what would the effect of that be?
The effect in the Riddick case of sending it back to, I would argue first in this case, because I think, don't let me mix them up, but Riddick, there's the motion to dismiss that it would fall back to the fact that the, not the paper, the document, the charging document before the court carries no weight. It legally means nothing.
It's a void document.
So if in the Riddick case, the court were to send it back, if the solicitor wanted to engage the court of inquiry, present evidence before a court of inquiry, then that is how it would, the Judge Ward in that case would have the legal authority to make findings to bind it over for probable cause. It's really just a situation here where there was nothing the court could do other than dismissing the case, or if the solicitor wanted to put up sworn evidence, or as the Judge Pitts, the municipal court judge in the Paris case, kept ruling over and over, you either have to swear out a warrant or you have to give me some evidence at a hearing. The prosecutors could do any of that. What happened here was that everybody just stuck to their guns that the citation was enough. The court lacks subject matter jurisdiction. The citation lacks the legal authority to charge this kind of a thing. It leaves the lower court with really nothing other than a dismissal.
Okay. Thank you, Ms. Johns. Ms. Comer, I'm going to let you have the last word.
Okay.
If you briefly want to address those issues.
Yes, really briefly. So I know the main thing, that is going on is the evidence, the issue with the evidence. I would want to point the court to the uniform rules of the Municipal Court of Georgia, rules 20.1 and 20.2. If we look at rule 20.1 and go down to B4, it says if the accused intends to plead guilty or waives the hearing, which is the probable cause hearing, the court shall immediately bind the entire case over to the court having jurisdiction of the most serious offense charge. And that's what was done here, especially in the Ivy case. The main thing is since the defendant had made bond, she had no right to a probable cause hearing where the solicitor had to present evidence. And that's the main thing. I feel as though that's what happened in these cases is that, since she made bond already, she had no right to a probable cause hearing. And clearly in that rule, it says that if they waive the hearing, which happened, then the court, the municipal court, shall immediately bind the case over to the proper court. And that's what happened. I would also point out that as a municipal court prosecutor, we're not limited, with regards to acting as a court of inquiry. I would point out a municipal prosecutor can charge any crime, a felony or misdemeanor in the scope of representing the state for the purpose of prosecuting a commitment hearing before a municipal court sitting as a court of inquiry, according to OCGA 15-18-96. So basically, when the prosecutor decides that it's appropriate to amend a charge from a city ordinance to a state misdemeanor charge, or whatever charge we decide to upgrade the charge to, as long as we're acting, as a prosecutor in a court of inquiry, then we're able to make any charging decision. So we do disagree that our powers are not limited. But here, I think the main thing is with the evidence. And I think the key is, since the preliminary hearing was waived, the solicitor did not have to put up any evidence. We had a right to motion the judge to bind the case over since she had made bond. Now, if she had not made bond, and if this was like an in custody hearing, then of course we would have to have a preliminary hearing on the new charge. But in this case, that wasn't the case. The last thing that I would say is I do think that the Riddick case is a little different, where we didn't amend or do anything with the citation. To us, it doesn't make sense to dismiss the case. We simply motion the judge to bind the case over to the proper jurisdiction, and that's what he did. So definitely in that case, we feel as though, the judge and the prosecutor did the right thing. And also with the Anthony Ivy case, she made bond. So technically, the solicitor didn't have to put up evidence on the simple battery charge.
Okay. Thank you, Ms. Comer. Thank you, Ms. Johns. I don't think it's going to be surprised to tell you that I think that Ivy is controlled by Paris versus the city of Atlanta, and that it's dispositive of the outcome. And so therefore, Ms. Johns, I'm still not quite sure what the relief is that you want, but I trust that you will send me a proposed order that grants the relief that you are seeking on the basis that Paris versus the city of Atlanta would applying that. There is no evidence that the case, let me say this again for my record to be clear. Applying the city, Paris versus the city of Atlanta, the municipal court in this case bound over charges without evidence of probable cause as to the additional count that would have been necessary for that enhanced charge of battery. And as a result, the holding of the city of Atlanta, of Paris versus the city of Atlanta would require that be reversed. And so if Ms. Johns, you will send me a proposed order on that issue, I will get that on file so the parties will have some clarity on the Ivy case. I want to spend a little bit more time with some of the case law regarding the Riddick case to make sure I understand it, because I think I've made clear that I think it's different. Two things are what I'm struggling with, just to give you some understanding of why I want to look at it some more. Number one is court lacks subject matter jurisdiction. They lack subject matter jurisdiction, and I'm struggling with the idea that they would have authority to exercise jurisdiction over this, even for the simple matter of making a finding of probable cause, even if that was an artifact in the order as opposed to an intentional finding, to bind it over to state court. Compare that, though, with the fact that I am also persuaded by the city's argument that the municipal court literally did nothing, right? They didn't exercise any authority or evaluation over the charges. They didn't add anything to it. They didn't take anything away from it. They just said, we're not the right court. Let's send it to the right court. But Ms. Johns, your point is one that is well taken, is that even at a high volume and even at relatively low charges, this process still matters because it is still the government exercising its ability to deprive people of their liberty. And so I take it seriously, and I want to look at it a little bit more to make sure that I'm comfortable with what that outcome is. So I'm ruling on the Ivy case. I am deferring ruling on the Riddick case, but my goal is to spend some more time with that this weekend and get you guys an answer at the beginning of next week.
Thank you.
Thank you both. I appreciate your time.
Okay, thank you so much.
Thank you. Have a good day.
You too.
Okay, counsel in the Bailey versus Patel or Patel versus Bailey, I forget which iteration we're at now. If you'll give me 5 minutes to go grab a little bit more coffee, then we will get started. Did you secure a court reporter?
We did not, but we're fine, Your Honor.
Okay, thank you very much. I appreciate it. You are free to go, Ms. Taylor. Thank you. Okay, I am back. I have more coffee, so I'm good. Thank you. And I'll note Mr. Ankoa, I'm sorry if I mispronounced your name, but you're not muted. So just want to let you know that you're not muted.
Okay, you got it.
Okay, so we are here on the Manesh Patel versus Stuart Bailey, case number 2022 CV 373930. Got Mr. Chavda here. I've got Mr. Thompson here. I know that we have some other people here who I assume probably are witnesses, or maybe just interested parties, not sure. Here's where I believe that we are. I think I said this earlier, but just to make sure we're all on the same page, I had entered an order dismissing a prior counterclaim by Mr. Bailey on the basis, Stuart Bailey, I will point out, because there's somebody here named Mike Bailey. I'm sure going to find out later who that is. But I dismissed that counterclaim on the basis that it was barred by res judicata, multiple counts of it were, and I dismissed those counts with prejudice. I allowed 2 of those counts to not be dismissed with prejudice, to allow the Mr. Bailey to assert, if he could, causes of action that were not derivative of the lease, which had already been on issues associated with the lease and rights that arose out of the lease had already been litigated and ruled upon by the court substantively in various iterations of this case prior to it resolving. And then ultimately what brought us back here was this consent order that fell apart because of the appraisal issue. So I think where we are procedurally and what I need to do is hear from Mr. Thompson regarding although there's a motion to dismiss, I believe Mr. Thompson is correct that typically we would focus our efforts on, it would be within the 4 walls of the complaint on a motion to dismiss, but that because of the unique procedural posture of this case, there is an avenue where it is required for Mr. Thompson on behalf of Mr. Bailey to be able to put some evidence on about the basis for the continued counterclaim. And so that's what we're here for today. And so, Mr. Thompson, I'm going to call on you. Do we want, assuming this is an evidentiary hearing, are we going to make argument and then hear from witnesses, or are we going to hear from witnesses first and then argument? What would you like to do, sir?
Well, Your Honor, let me first point out that the other Mr. Bailey that you see on screen is my client's family member who simply wanted to attend.
I assumed because of the last name, but I didn't want to make any, assumptions without asking. So
sure. I think from our perspective, there is some divergence of viewpoint with regard to why we're here today and what can occur today. I think actually that starts with the very first sentence of the statute upon which Mr. Patel's motion to dismiss relies, and that is OCGA 911-41B. Obviously, OCGA 911-41 concerns voluntary and involuntary dismissals, and Mr. Patel has presented his motion based upon the involuntary dismissal provision. The first sentence of that reads, "For failure of the plaintiff to prosecute," which is not the issue here, "or to comply with this chapter," which is not the issue here, "or any order of court, a defendant may move for dismissal of an action or of any claim against him." To the extent Mr. Patel is relying upon this provision, based upon an alleged failure to comply with any order of the court, we would argue that it's premature. There's been no determination that Mr. Bailey has failed to comply with any order of the court. Your Honor, as you noted in your order of April 25th, 2023, you gave Mr. Bailey the opportunity to present claims not based on the lease. On May 25th, Mr. Bailey restated his counterclaim, and he is in fact bringing claims that are explicitly not based on the lease. In fact, the dispossessory claim he's bringing is a statutory remedy that the legislator has allowed for landlords when dealing with holdover tenants. It says on its face that it applies whether under contract of rent or not. So under the dispossessory action, the restated counterclaim for dispossessory that Mr. Bailey has brought, he has fully complied with the court's order. So we would submit that the court cannot consider a motion to dismiss under OCGA 91141B because there's been no satisfaction of the conditions proceeding. That being,
but I mean, here's where I continue to get hung up on this. And dispossessory is typically used to dispossess someone from a property who no longer has a legal right to be in possession of the property.
right.
And through the various iterations of this case, what the court has consistently found is that Mr. Patel has at least a facially valid basis to remain in the property until we figure this all out, which Mr. Bailey conceded, right, functionally, when y'all entered the consent order to resolve the case, and to go forward with the sale to Mr. Patel, subject to this issue of the appraisal that fell apart.
Well, Your Honor, I believe that, well, Mr. Chavda has, as you are well aware, consistently pointed to the doctrine of res judicata. I believe he's expanding that doctrine a bit beyond its bounds. Res judicata is not an issue here. The issue here with respect to both to the mediated settlement agreement as well as the consent order upon which it was based, the issue here is that those are not enforceable because they lack material terms. And the doctrine of res judicata cannot serve to make unenforceable agreements enforceable. You can't come along and say, hey, well, you didn't raise the unenforceability of those agreements before, so therefore you can't raise it now. The Georgia Court of Appeals has, and in fact, the Georgia Supreme Court have consistently said unenforceable agreements do not exist. So there's nothing upon which to base the mediated settlement agreement or the consent order, which the Supreme Court has also said is in effect an agreement and should be analyzed just like any other agreement. So it's not an issue of res judicata. What I am saying is that those documents upon which the parties may have relied earlier are simply not enforceable because they lack material terms, and to the extent the court seeks to enforce it, then it becomes a more practical problem. Upon what terms? How do you enforce an unenforceable agreement that lacks the necessary terms that are themselves giving rise to the argument? So we're outside of the res judicata bounds at this point. The question is the viability of those agreements upon which the parties entered previously.
I understand that, Mr. Thompson, in terms of that, we are essentially the original way that this case in its current iteration is before the court is on a petition for injunctive relief to enforce the settlement agreement. But your arguments on behalf of Mr. Bailey about why the settlement agreement aren't enforceable go back and attempt to relitigate issues that the court already, it's not res judicata of the entire action, it's issue preclusion, right? Of the particular issues that if I were to allow your counterclaims to go forward, you would be asking the court to relitigate and redecide substantive legal issues that the court already decided on in the prior case before y'all entered into a consent agreement. How does that not preclude the court from going back and, sure, we can look at whether there was a meeting of the minds as to the agreement that the parties entered into that resulted in the consent order, because I agree with you, case law is clear on that. It was a contract, does it meet the elements, whatever. But whether or not there was an option that was enforceable, the court's already spoken to that, hasn't it?
Well, Your Honor, we also assert that the option itself was unenforceable. The option.
Right, I understand that, but haven't I already said, yes, it was?
Then the question becomes, how does the court enforce an option that lacks necessary material terms? Under the law, the court cannot impose those terms, and neither party at this point can unilaterally impose those terms. And so we find ourselves, I mean, if there are two things that are true, if the relief that Mr. Patel is asking for is allowed, number one, we will find ourselves on essentially a hamster wheel whereby we're continuing to argue about the necessary and material terms that are missing and gave rise to the dispute in the first place, number one. And number two, if the relief that Mr. Patel is asking for is granted, then in effect, the court is creating a property interest that is not recognized under Georgia law. Mr. Bailey is the owner of this property. If Mr. Patel is granted the release he's asking for, then he is a tenant with an indeterminable term, in fact, potentially an indefinite term. And the owner of the property, even though the lease has terminated and everyone agrees that the lease is terminated, the owner of the property has no right to regain that possession. That's a property interest that is not recognized anywhere under Georgia law, which is why we believe the relief that Mr. Patel is asking for is untenable.
Okay. Okay. Anything else? I'm going to let you have the last word, but I want to hear from Mr. Chabda unless you have anything else to add right now, Mr. Thompson.
Other than the fact that we also, I don't want to come across as saying that nothing that the parties have agreed to or tried to agree to is right. What I'm saying is that there are gaping holes at each step of the way. I believe both Mr. Bailey and Mr. Patel have been forthright in their dealings with one another in efforts to resolve this. But unfortunately, there are gaping holes in their attempts to do so. And under the law, that renders that ineffective such that, you know, even if the court were to order additional appraisals, then the question becomes, how do you enforce that when the agreement that brought up the appraisals in the first place lacks necessary material terms such that the parties will just continue this argument?
Right, but if the court were to determine that there was a meeting of the minds, right, to accomplish the resolution of the case, to sell the property from Mr. Bailey to Mr. Patel as part of an agreement to resolve the litigation, doesn't the case law authorize the court to determine what the material terms were and or to enforce them if the parties didn't agree on certain material terms?
Well, to the extent the parties have agreed on certain material terms, I would say absolutely. To the extent that there are not material terms and the goal here is resolution of the case, I would say the court does have some role. But I believe there's a limitation in those roles. For example, part of the reason that the contemplated appraisal process did not work was because the appraisal that Mr. Patel came in with was extremely low, extremely undervalued, to the extent that Mr. Bailey hired another independent expert to review that appraisal, who found that Mr. Patel's appraiser used the wrong methodology, assumed the wrong zoning, did not account for the income opportunity of the property, and that's what accounted for the much lower valuation. In fact, Mr. Bailey has recently gotten offers to buy the property that are much closer to the appraisal that he submitted. So in order for this to work, the court then would have to impose terms to contemplate those types of issues. And I don't know for sure that the court can. And so that's my concern.
Okay. Thank you, Mr. Thompson.
Sure.
Mr. Chabda?
Thank you, Judge. I will start by saying that the goal for this case and every other case that I'm a part of is to resolve it. I'm not trying to take this to a bench or jury trial. The goal from day one has been, let's resolve this thing, because there are certain terms in here. Yes, there was no avenue of dispute resolution if one of the appraisals comes back at a skewed valuation. And just to clarify what Mr. Thompson said, it wasn't Mr. Patel's appraisal of the property that came in the lowest.
I've read the materials. There were 3 appraisals. 2 were supposed to be gotten independently by either side. 1 was supposed to be by some independent. And basically what happened is the numbers came in. I'm sure Mr. Thompson, as he just said, the Mr. Patel's numbers came in way too low. Mr. Bailey's numbers came in way too high, and the parties refused to agree to a sale price. But I mean, I'll just point out it's been patently obvious through the course of this litigation that Mr. Bailey does not want to sell the property to Mr. Patel on the terms that he potentially, maybe not enforceably, according to Mr. Thompson, but on the terms that he at least facially agreed to back when Mr. Patel began renting the property. I mean, that's what this litigation has always been about. So it's not surprising to me that Mr. Bailey balked at what the values were, and that he would be unhappy that there are offers to purchase the property that are much higher now, because of course that was more than 5 years ago. That these negotiations were had about an option to purchase.
Right.
Go ahead, Mr. Chapman.
Thank you. And it was Mr. Patel's that came in the middle. The independent appraisal is what came in the lowest. But nonetheless, going to the res judicata argument, Mr. Bailey's counterclaim, the restated counterclaim, states that the demand letter that he sent in November 2022 is what kind of controls here for the tenant at sufferance argument. And so there's only 2 points in that letter that are relevant here, in my opinion, in our opinion. And I'll read it out. It says, Mr. Patel's right of possession of the premise expired on June 30th, 2019. You remain in possession of the premise without landlord's acquiescence and are a tenant at sufferance. So in June of 2019, July 1st, I guess, of 2019, we were still in this litigation. Mr. Bailey filed the first one in February of 2019. Mr. Breedlove had an argument of a holdover tenant back then, and that's what Mr. Thompson just cited as well. So that was already, we already handled that in the first case. The second, and of course, Mr. Patel has been in continuous possession of the property since 2009 when he paid that $96,000 to Mr. Bailey. And the second point of that particular clause is that the claim ignores the assent that's provided by Mr. Bailey for the original option, the settlement agreement, and the consent order. So not only did Mr. Bailey agree to it, there's his signatures on the original option and on the mediated settlement agreement, but he actually took additional steps to conform to them. He got his own appraiser that provided him an appraisal. He paid for half of the cost of the independent appraiser. And we're here, as you correctly stated, because he didn't like the purchase price that resulted. And the second point in the demand letter is that, I'll read it out again. Landlord and tenant released all claims against each other accrued through December 16th, 2021, under the terms of the mediated settlement agreement as of that date. So Mr. Bailey is citing the mediated settlement agreement, the release provision in that mediated settlement agreement in that original demand letter that he sent. And so we're to believe that he considers it to be valid. Otherwise, why would he cite it? And it allows him to continue forth with this claim of dispossessory against Mr. Patel. And that kind of goes to the next point of the deck judgment and the ongoing recurring argument of the lack of material terms. So in Mr. Thompson's brief, he says that the lack of material terms are how the option is exercised, when, how the closing is to occur. All of those are accounted for within those documents. We know how the option is going to be exercised after the appraisals, and then there's a purchase price that results. There's a very detailed calculation on how the purchase price is going to be handled. When is the closing going to occur? 90 days after the fair market value. That says it in there. How is it going to occur? That's simple. Mr. Patel pays Mr. Bailey, deed is transferred. It also discusses that there's no due diligence, property is sold as is, what to do if either party doesn't perform, the funds in registry. And it also has the provision in there that if the parties back then failed to assign an appraiser by January 2022, that the court would determine who would conduct the appraisal. And so the material terms are present. And then I will add to your question to Mr. Thompson earlier, there's a case that he cited, the Ackerman versus Whitmer. And there's the last sentence in there that's missing from the quote in Mr. Bailey's brief. And if the court would allow it, basically, I'll just read it out. And it says that an indefinite contract may acquire more precision and become enforceable because of the subsequent words or actions of the parties. So even if the court accepts that the material terms are missing, the settlement agreement and consent order has to be enforceable because his actions and words show that he believed that they were enforceable back then.
Okay.
May I, Your Honor?
Hang on one second, because I promise I'll let you have the last word. I do intend to, but Mr. Chavda, I do want you to address. So one of the things that it seems to me part of the problem that I'm having with and I think the reason I previously dismissed the counterclaims is that all of the claims require or request by Mr. Bailey, request the court to go back and reconsider whether or not the option itself was valid and enforceable. And to me, that ship has sailed, and that the contract that the court should be focusing its consideration on is the mediated settlement agreement and whether those terms were valid. I think I understand part of Mr. Bailey's argument here today to be, if there was no agreement, then the court is free to go back and reconsider the validity of the option contract. What say you to that issue, sir?
Well, I think so as it says in the mediated settlement agreement, it does have a provision for that in there. There's a excuse me for 1 second. I will pull out the exact language of that. I apologize.
That's fine.
All right, so page 3 at the top of the mediated settlement agreement, it states that the parties agree that this mediation agreement is binding on all parties and is not subject to revocation by any party. We contemplated that the parties had a 7-hour mediation for that particular day. We came up with the roadmap, and that was the decision that both the parties came to. Both our respective clients signed the document, and then we put it forth in front of Your Honor, and then Mr. Breedlove and Miss Mowry and we came together and we came up with the consent order. So it was that roadmap was essentially what resulted in the consent order, which is again binding upon the parties.
Okay. Thank you, Mr. Chavda. I appreciate that.
Thank you, Judge.
Mr. Thompson?
Well, with respect to that last point, we of course agree that the consent order was premised on the mediated settlement agreement. But we also assert that that's the problem, because the mediated settlement agreement itself lacks necessary and material terms. We've all been doing this long enough where we've seen parties who very desirous of resolving something of some dispute attempt to do so. But that doesn't mean that their efforts in doing so are legally viable. I take issue with Mr. Chavda's argument that even the option agreement was valid, in that, you know, it doesn't, what he described is not a closing. The time, place, and manner of closing have to be spelled out. And aside from the fact that it's our position that the option was never exercised, we've never seen any piece of paper that speaks to exercising the option. So as far as we're concerned, that option's gone. But if you start with the recognition that the option agreement itself was invalid at the time, and the parties in good faith trying to resolve this matter came together at a mediation and sought to do so, that in and of itself doesn't satisfy the law. There have to be necessary material agreement provisions and terms have to be in there. And despite their good faith, despite their belief, if they're not, the court has said that those agreements do not exist. The other thing Mr. Chavda said, I mean, he sort of glossed over it, is with respect to the holdover tenant issue, he said, we've already dealt with that. Actually, no, the status of holdover tenant is one that's by operation of law. If your tenancy ends, if the lease terminates and you're still there, you are by definition under the law a holdover tenant. Now, the lease, understanding that we're not dealing with the lease anymore, the lease contemplated that and had a holdover tenant provision. But even if we're not dealing with the lease anymore, the law says that Mr. Patel is a holdover tenant. And the law gives Mr. Bailey the right under OCGA 44-7-10 and 44-7-50A to come in and demand possession of his premises.
Right, but the problem I've always had with that is, again, the idea of dispossessory assumes that the party has no legal claim to the property, number one. Number two, I have already denied an effort to dispossess Mr. Patel, requiring that he continue to pay rent, which he did until the parties resolved the case. And so by your logic, you alleviated the obligation of Mr. Patel to continue paying rent to you, because I think I remember that he'd already exceeded the amount that was owed on the loan that he'd been paying it to. But setting that aside, by your logic, Mr. Thompson, Mr. Bailey would release Mr. Patel from the obligation to pay rent, but then go back and say, you haven't paid me rent, so I'm dispossessing you. That doesn't make logical sense to me.
Well, no, Your Honor, he was not released of the obligation to pay rent. The expectation has always been that he pays rent. In fact, the expectation has been that he pay the holdover rent amount of 150%.
Up until the consent agreement, the mediated settlement agreement, what did that require Mr. Patel to do other than for the parties to make effort to get appraisals and consummate the sale of the property? Did it require him to continue paying rent?
Let me pull it up.
I don't believe it's been, I may have overlooked it, but I believe what's been represented to me is that it did not, because the parties anticipated, I think in good faith and mediating a settlement agreement, that y'all would be focusing your efforts on selling the property, not continuing to rent it. Mr. Chabda?
Judge, 4A says that defendant, that's Mr. Patel in the prior case, shall continue making payments on SBA loan held by Fidelity Bank.
Okay, and has that occurred?
Yes, Your Honor. He's been paying, as of September 2023, he's paid a total of $376,000. That's almost, $80,000 more than the balance of the loan.
Okay. So the reason I went back to that issue is whether he was not paying because he'd been relieved of that obligation, or he was continuing to pay. The prior injunctive order that the court entered was that Mr. Bailey had no authority to dispossess Mr. Patel so long as he continued to pay. And it seems like the court, it seems like the parties included that in their agreement.
Well, Your Honor,
it was enforceable.
If that's the case, if it's Mr. Patel's position that because the SBA loan has been paid off, that he has no actual obligation to pay rent, that's a further infringement of Mr. Bailey's rights. Going back to the argument I made earlier about the creation of a new property interest that does not exist under Georgia law, what Mr. Bailey is now being told is that you can own a property, you can have a tenant in that property, that tenant doesn't have to pay you rent if they don't want to, and all of this is arising from a mediated settlement agreement that's not enforceable.
Okay.
It's a clear infringement of his rights.
Okay, let me ask a couple of questions. Mr. Chabda, if the court declines to dismiss the counterclaims, what is the procedural posture of this case and what should the court do with it next?
So before I answer that, Judge, if I could make a point, so give me a second to think about it. But what Mr. Thompson just said about the alleviation to pay rent, if not going back and relitigating the case, but just to point out certain facts way back when 2007 to 2011, Mr. Bailey didn't pay taxes on the property.
Mr. Chabda, I remember all of those facts.
Right.
You don't need to refresh my recollection. And,
Yeah.
and here's why I'll say this. I don't necessarily care about those facts. What I remember that matters to me is that the evidence in the prior case seemed to indicate that Mr. Patel was continuing to make monthly payments under the terms that he understood. And that Mr. Bailey was benefiting from the payment of those payments by Mr. Patel, either because they were going to lower his line of credit with the financial institution where he was paying those funds. I remember all that stuff. You don't have to go back into it.
And it's not to go back to specific detail. The reason I bring it up is because 296. I don't know what the exact loan amount was at a certain point. The purchase price was 296, but the attorney's fees and the other costs that were associated with the tenancy and the option prior to Mr. Patel taking possession is the reason why the full balance hasn't been paid off yet. So there's still a balance on the loan, and that's something that I wanted to bring up after the fact. But
the court also took under advisement in its prior order the award of attorney's fees, which had been requests had been made for, and has not ruled on that issue, has continued to hold it in abeyance. So,
right. But to answer your question, if the court decides to let Mr. Bailey's dispossessory claim continue, I think depending on how much is left on the loan itself, I think Mr. Patel, number one, Mr. Patel should be able to stay in the property. That shouldn't really change. In the grand scheme of things, Mr. Patel has paid much more than he had contracted for in the beginning, and a reasonable outcome on the prior case, if we would have gone all the way, would be, even if Mr. Patel would have lost the prior one, would be the return of all of his rent proceeds from the beginning of from the time that he started paying. Georgia law supports that, certainly. And
I understand all that, but that's actually not my question, Mr. Chopper.
Right.
My question is procedurally, right? Where does this case go next? If I were, because I'm going to ask the same question if I dismiss the counterclaim, right?
Right.
There's not a request in the nature of the relief sought by the petition does not imply a jury trial. It implies a bench trial or, hearing by the court. Is that what's next? And if so, from your perspective, does the existence or does the dismissal or refusal to dismiss the counterclaims change where this case goes next and how soon it would go to that next procedural step?
I think the scheduling order that was sent by Mr. Freehoff, the expedited one, is something that I would ask for.
It was vacated. So.
Right, understood. But it was still something that is probably necessary in this case. A 1 month discovery period for both sides, including depots, then dispositive motions, and then a bench trial. I think by November we could have this thing sorted out.
Okay. Mr. Thompson, same question, but in reverse. One, do you agree with his assessment of what is at issue in the case? And does whether or not I dismiss the counterclaims, does it change any of that in terms of what the court has to consider?
Thank you, Your Honor.
Substantively, to decide the rights of the parties.
Does your question assume that we would not get a certificate of immediate review?
Well, you haven't asked for one, so I am not going to say you wouldn't get one. I'm usually pretty free with them, but I will tell you that I am cautious sometimes when I am concerned that an appeal, that a certificate of immediate review and interlocutory appeal is, I would review it to make sure that I was satisfied that it wasn't being interposed for purposes of delay. But beyond that, I typically don't like to stand in the way of parties' rights to vindicate their appellate rights when they disagree with one of my rulings. So.
Okay. So since your question goes to the procedure, let's set, I guess, that issue aside then for the moment. I would largely agree with Mr. Chavda about the issues to be litigated. I think November is a bit aggressive, but not by too much.
I think I agree with you there. I think November would be awesome, but the December or January is probably more likely in terms of how it actually will work for y'all to get these depositions scheduled with the intervening holidays and everything else. But go ahead, Mr. Thompson.
That was my thinking, but I do believe that the remaining issues would largely be the same. And we would then have a process at least to sort them out via discovery and argument. Yeah, so that's, you know, with the caveat from the outset, that's, I think, where we stand.
Okay. Okay. So, I ordered, when I ruled originally on the counterclaim, right? So Mr. Patel filed this motion for declaratory judgment, injunction, whatever we want to call it, asking the court to enforce the settlement agreement that the parties had arrived at in resolving the prior 2019 case. Mr. Bailey filed a counterclaim. And at the time, as I said, the counterclaim was essentially all of it was built on arguing that underlying past matters that I felt like the court had already addressed were inviting the court to relitigate. And I didn't think it was proper for the court to relitigate, which is why I granted the motion to dismiss a number of those counterclaims with prejudice. But I gave the opportunity to Mr. Bailey to assert a new counterclaim based on new counterclaims, if he could, that were based on something other than the prior lease agreement, based on something other than the offer, et cetera. And here's what I see when I look at this claim is a request for declaratory judgment to declare that the mediated settlement agreement is not valid, which is what is seeking to be enforced. Ultimately, that's probably more of a defense than it really is a counterclaim, but nonetheless, I think it's properly cast to challenge something that has not been decided by the court, which is whether or not the agreement that the parties mediated and arrived at in the settlement is valid. It's a motion to dismiss, so I'm not going to address the merits of the dispossessory, but I will say that all things being equal, I think that Mr. Bailey has attempted to comply with the court's order to recast the counterclaim based on things that do not arise directly from the lease agreement. Whether or not there is relief that can be had on count one of the dispossessory, in my opinion, you can call it whatever relief you want. It's not even really a cause of action. It's relief that Mr. Bailey seeks because Mr. Patel continues to be in possession of property that Mr. Bailey claims that Mr. Bailey clearly still owns, but that Mr. Bailey claims Mr. Patel has no legal right to possess. And that's ultimately the issue in the case. And if the consent agreement is enforceable, then Mr. Patel has a right to possess that property. And if the consent mediated settlement agreement is not enforceable, then the court will have to figure out what that means amongst the parties. And so I'm going to deny the motion to dismiss. The restated, and I will note, as of I think yesterday or today, verified restated third counterclaim will continue to exist. And I'm going to deny Mr. Patel's motion to dismiss that restated complaint. I am not going to change the current circumstances, which is that Mr. Patel continues to remain in possession of the property. But that is largely not because I'm pre-deciding anything, but because the dispossessory to me is inherently tied into whether or not there is a settlement agreement, which is the relief that Mr. Patel is seeking to enforce the settlement agreement he believes they have. And so I'm going to continue the status quo between the parties, which is that Mr. Patel remains in possession of the property while we litigate this. If I need an order, then the parties, if we need an order to that effect, then I will consider one if the parties want to present it to me. But I think currently the parties may be in a stasis of their own. But if they're not, and there needs to be some order to give the parties clarity, I will do it. But to be clear, Mr. Bailey, as I said in the previous litigation, while we're resolving this issue, Mr. Bailey has no right to and may not pursue a dispossessory action in the magistrate court. Any dispossessory action will have to come through this court as a result of the resolution of these substantive issues, or some failure on the part of Mr. Patel to comply with whatever the obligations the parties agreed to. So that's going to be my ruling. Mr. Thompson, can you please provide me with it doesn't need to be a big, long, essay, but if you could please provide me with a proposed order denying the motion to dismiss the third counterclaim, the third restated counterclaim.
Will do, Your Honor.
And then what I will do, it sounds like the one place the parties are in some agreement on is that notice of intent and scheduling order would be helpful for the parties. And so what we will do is we will identify a time, usually a day or week, that we would place this on a calendar, and we'll reverse engineer some dates for you that will give you an abbreviated, maybe 30 to 45 days for some discovery, and then some additional brief time for motion practice. And then looking at a hearing date in either December or early January. I tell you all that now because it might take me a day or two to get that order on file. And I want y'all to be clear that the order we enter is going to require and expect very expedited discovery from the parties. And so I would expect that both parties have an interest in vindicating their respective rights and having this finally put to rest through the sale of the property, whether it's to Mr. Patel or to somebody else. If Mr. Bailey is able to persuade the court that Mr. Patel is not entitled to purchase it pursuant to the terms of the settlement agreement. I think that's all that I need to do for today. Is there anything else that you need from me, Mr. Thompson or Mr. Chavda?
Yes, one point, Your Honor. Can we arrange it so that Mr. Patel is no longer making payments on Mr. Bailey's behalf? We are separately in argument, frankly, with the bank regarding the bank charges. And so Mr. Bailey would like to resume that on his own.
And that's actually why I mentioned if y'all need an order from me, because I do remember in the last case, there was some discussion of whether it would be better to have Mr. Patel. I don't care how it's paid. I don't care who pays it. What I care about is that there is documentary evidence that the parties can't really dispute that Mr. Patel made the payment in a way that was for the benefit of Mr. Bailey. Previously, the parties had agreed, even through the conduct of the litigation, that Mr. Patel would pay it to the financial institution. If that's an issue and y'all want to discuss paying it elsewhere, that's fine. What I don't want to do is revisit or reopen disputed issues about amounts or anything else. My purpose is all of this should remain status quo. And if y'all can negotiate that Mr. Patel's payment will go elsewhere, as long as there's proof satisfactory to Mr. Patel and Mr. Chavda, that Mr. Patel will be able to demonstrate that he made those payments and timely, et cetera, in the amount that was previously entered, right? Which I know is a fairly low amount, but we're not changing any of those things. If you want to negotiate that with Mr. Chavda, I encourage you to do so. If you cannot resolve it, then let Mr. Freehoff know that you need a discovery conference or some sort of informal conference, and we can just have a phone conference and I can issue an order that, will tell Mr. Patel where to send those payments so that Mr. Bailey is getting the benefit of them and Mr. Patel is still getting the credit for those payments.
Absolutely. Okay, will do, Your Honor.
Okay. Anything else, Mr. Chavda?
Yes, Judge. Just can we add in the order something that you said is that Mr. Bailey cannot sell the property to anybody else while this litigation is pending?
Right. And I believe that has been previously in the case. And I would agree. Whatever order, he can't dispossess Mr. Patel and he can't alienate the property until we resolve this issue.
Thank you.
Okay. Anything else?
Nothing from Mr. Bailey, Your Honor.
Okay.
Nothing from us either, Judge. Thank you.
Thank you both. Have a good